Forthwell Limited against Pontegadea UK Limited.
Yes, Mr. Thompson.
Good morning, my Lord. In this appeal by Forthwell Limited against Pontegadea UK Limited, I appear for the pursuer and appellant, along with Mr. Ford, my learned friends, the Dean of Faculty, and Mr. Reid appear for the defender and respondent. In terms of Rule 36.1 of the Rules of Court, I'm obliged to inform the Court that parties to this action have settled all disputes between them, including as to the disposal of the present action. I was made aware of the fact of that settlement at 7 p.m. last night. The written settlement agreement, as I understand it, was signed at about 9 p.m. and the settlement was communicated to the registry shortly thereafter. As a result of that settlement, the present appeal will now have no practical effect so far as the interests of the parties to the action are concerned. Now, while the settlement of this long-running dispute is good news for the parties to the actions themselves, and indeed doubtless to the patrons of the Rogano, I fully accept that settlement of the proceedings on the literal eve of the appeal before this court is, to put it mildly, highly unsatisfactory.
Yes, that is putting it mildly. Are you then applying to withdraw the appeal?
So, my understanding, my Lord, in terms of Rule 36 and Practice Direction 8.6 is that it's stated that it's the duty of parties in those circumstances to lodge an application to withdraw the appeal of consent, and that has been done. However, one recognises...
we haven't seen one. When was this done?
As far as I was aware, my Lord, that was sent to the registrar last night. What I was going to go on to explain, however, is this.
I don't think it can have been, or we'd have been told about it. The solicitors sent an email to our registry after 9 o'clock last night saying that an application to withdraw the appeal would be submitted once they had a signed agreement from both parties.
I wonder if I may just check. So I'm instructed, my Lord, that the application to withdraw was sent at about 11:30 p.m. with the requisite fee.
About 11:30 last night?
Correct. Now, plainly, and notwithstanding the fact that Council were not involved in the negotiations that have led to this settlement, it's a matter of considerable professional embarrassment to me appearing before this court that these circumstances have arisen, and for my part, I certainly apologise to the court. But as I've indicated, my Lord, I recognise that the court has a discretion as to how it wishes to proceed in these circumstances, and I am expressly instructed to indicate to the court that the appellant is quite content to proceed with the appeal if that should be how the court wishes to proceed. A couple of points I should mention in that connection. First of all, in my submission, the subject matter of the appeal does very obviously raise an arguable point of law which is of general importance.
Yes, I think we granted permission to appeal on that basis.
It was the inner house that granted permission in this case, but plainly that's the territory we're in.
Yeah.
The other thing that should be mentioned, but the court will not be aware of this if it's not seen the application to withdraw. I'm aware from my own personal involvement in it that there is another case before the Court of Session called Simmers against Green Cat that went to debate before Lord Braid, the commercial judge in this case, after the Inner House had advised its opinion. A reclaiming motion has been marked in that case, and that action is sisted pending the outcome of the present appeal. So there is one definite other case that does turn on the issues raised in this appeal. And finally, apart from the interests of the court and the public interest, I also recognise that there's considerable public interest in this appeal in the whole circumstances. So in the unfortunate and regrettable circumstances that have arisen, as I've indicated, the appellant is content to proceed with the appeal if that is how the court wishes to proceed.
Yeah. Can you explain how it comes about that the settlement discussions took place at such a late stage that the application to withdraw the appeal is only being made, was only apparently made at 11:30 last night?
So working back from when the application was submitted, settlement terms were only agreed at 7 p.m. last night.
Yes, but I mean, this hearing was fixed a long time ago.
Of course.
So one would have thought that if the parties were interested in negotiating a settlement of the case, they wouldn't have waited to the last minute.
Quite so, my Lord. In broad terms, as I understand the chronology, there were attempts to consider resolution of the dispute by mediation in around December last year. Those attempts failed. The parties considered they were too far apart. There were some discussions in December and January about extrajudicial settlement on commercial terms. In the course of March, some discussions took place. And then I first became aware that there had been, I was wholly unaware there were discussions taking place. I first became aware there were discussions taking place on the Friday before last. And it's only in the course of the last week that the parties have been able to resolve the gap that existed between them. So I can't present that to the court as an acceptable narrative because it's not. But that is the position.
Well, we're very grateful to you for your explanation, Mr. Thompson. Perhaps we'd better hear from the Dean of Faculty what his position is.
My Lord, my Lady, I share my learned friend's professional embarrassment at the situation that has arisen. I echo his comments that Council have played no part in the settlement discussions, and my awareness of those discussions was even more recent than that of my learned friend, and I'm frankly mortified to be standing here in this situation. My instructions regarding the running of the appeal are to read the room. Reading the room, if the court wants this case to proceed, it will. And one of the criteria that the court would want to know is, will this case be properly argued? I can assure the court it will, because as the court will understand, this case has been fully prepared on both sides, and I am here to present a full argument for the respondent.
Yes. Yes, do you appreciate the bench has also prepared the case?
Absolutely. Absolutely.
Yes.
In faculty, could I just clarify one thing?
Yes, ma'am.
Is the settlement dependent upon the application for leave to appeal to be withdrawn being granted or not?
It is not.
Thank you.
It is dependent, is it not, on the application being made and you consenting to it?
Indeed.
But not on the court necessarily upholding the application.
Indeed. Certainly I can say from this side of the bar, and I'm sure my learned friend's in a similar situation, parties have been told it's not within the gift of parties in a case such as this, especially given the 2 minutes to midnight nature of matters, to say that the court will not be hearing from us. So certainly those instructing me and the underlying client have been told it is not open to us simply to say that's it, bags packed, we're off.
Yes.
That is understood.
Yes. Can you help us? I mean, clearly, given that the parties have reached an agreement as to how their dispute should be resolved, if we do hear the argument and give a judgment on the case, it won't be of any practical significance to the parties. A question is whether it would be of assistance to the legal profession and the judiciary more widely for us to resolve the legal question raised by this case. I'm wondering, it might be helpful for us to hear from both you and Mr. Thompson on that question. I mean, to what extent is the issue, do you think, one that is tied so closely to the particular facts of this case that it wouldn't be of great assistance for us to give a judgment, or on the other hand, is the issue one that is troubling the legal profession, and on which it would be valuable for us to give guidance?
My Lord, in my respectful submission, we're very much in the latter territory, and I say that, I think, for three reasons. Firstly, there is a fairly robust dissent from the Inner House, in the Inner House from Lord Malcolm. Secondly, as my learned friend has adverted to, there is another case sisted pending the result of this case. And thirdly, and here I'm going to speak rather counterintuitively, part of the reason why I will urge this court not to accept the development urged upon the court by my learned friend is the very wide-ranging nature of that. But if I'm wrong about that, this affects all contracts in one way or another, struck in Scotland or under Scots law. So does it have wide-ranging effect? Absolutely, if my learned friend is right.
Mm-hmm. I mean, if we speak about it for a moment in legal terms, there's an issue about whether effectively damages can be recovered for the loss of the performance interest, regardless of whether the actual loss in pounds, shillings and pence has been suffered by the contractual party or by some associated body.
Yes.
Now, in this case, there's no dispute, as I understand it, or certainly the issue before us doesn't concern the repair costs of the building.
Correct.
So there's no dispute that the tenant is entitled to enforce and to recover damages for a breach of the repairing obligation, insofar as those concern the costs of repairing the damage to the premises.
Absolutely.
Yeah. The issue in dispute is whether a consequential loss of profits by an associated company is recoverable by the party to the contract, which doesn't itself suffer that loss. That's it in a nutshell, I think.
It is.
And is it an analogous issue that arises in an assisted case?
Yes, it is.
Right. Okay.
So it will be. It was as it happened in terms of the way that the cases were allocated. It's Lord Braid who heard Simmers and Green Cat. Lord Braid, of course, having been the judge at first instance in this case.
Yes.
So Lord Braid, by then, in light of the majority decision in Forthwell, issued the decision he did in Simmers.
Yeah.
But yes, it is inevitable in my submission that the result here, if the court does hear it, will be impactful, will be dispositive of the decision in Simmers.
Yeah, I see. Thank you very much, Dean of Faculty. Ms. Thompson, is there anything you'd want to add in relation to the latter point?
So far as the general importance of the point of law that is raised by this appeal, I would endorse what was said by the Dean. This is, in my submission, a point of interest to the profession as a whole. It's a largely unresolved issue in the authorities.
Yes. Well, thank you very much. I think what we'll do is we will adjourn for a few minutes to consider how we should proceed in this situation. Well, we have decided that we should hear the appeal, even though the parties have resolved their private dispute. It's a matter of public importance that the time of this court is used in the public interest, and it's in the public interest that we should resolve the legal question raised by the case, which will be important in other cases, including a case that we're told is currently awaiting the decision of this appeal. So we'll proceed. Now, can I say, Mr. Thompson, we were having trouble hearing you, and I imagine people in the room are also having trouble hearing you. If you perhaps if you perhaps try to speak more into the microphone and keep up your voice, that'd be very helpful.
I shall, my Lord, yes. So this, of course, is an appeal against the interlocutor of the First Division of the Inner House of the Court of Session, dated the 31st of October 2024, by which the defender's reclaiming motion was allowed in part, and the defender's seventh plea in law, which was a plea on the merits directed towards the proposition that the pursuer was entitled to recover the losses of Lynette, was sustained. The motion which I was to have made on behalf of the pursuer and appellant is set out at paragraphs 4 and 5 of the written case. In light of the settlement of this case, of course, I don't need to make that motion, and one imagines that it will be sufficient in this case for the appeal to be refused, whatever the outcome of the judgment is. In the statement of facts and issues, the parties identified 4 issues or questions which arise in this appeal. They are set out at pages 8 and 9 of the main bundle. In my presentation, I will deal with the first 3 questions. Mr. Ford will deal with the 4th. The first and second questions identified by the parties concern whether, and if so, in what respects and on what grounds, Scots law recognises the concept of what has been described as transferred loss. The third question raises certain procedural issues, including as to the form of the conclusions in the summons. That issue I'll take quite briefly, not least because it's a very practical issue which has less significance in light of the settlement of this particular dispute. In addition to dealing with those 3 issues, I will of course seek to respond to the principal arguments advanced by the respondent in its written case. Once I have covered that ground, Mr. Ford, as I've indicated, will deal with the 4th question, which concerns the question of whether there is an obligation to account in the event that it's found that the pursuer is otherwise entitled to recover damages. The broad structure which I intend to adopt in these submissions is as follows. There will be 5 chapters to my submissions. The first will involve an introduction and overview of the law of transferred loss as it arises in the present case, focusing upon the key themes, as it were, of the appellant's case. The second chapter of my submissions will involve a detailed examination of the speech of Lord Clyde in Panetown, and also of Lord Drummond Young's opinion in the case of McLaren Murdoch. I will also examine and consider the subsequent outer house cases which have arisen in relation to transferred loss, namely Marcus of Aberdeen and Axon Well.
Are you going to say anything about the approach favoured by Lord Griffiths in the earlier case, I think Leinster Sludge, and then picked up by Lord Gough in Panetown?
So far that concerns obviously the broader ground as it's described, the performance interests which your Lordship referred to earlier. That is not the basis upon which the appellant puts its case. And I'll explain shortly what the different views are and what the case the appellant is advancing amounts to. So it's not my intention to examine the broader ground in detail.
Except the third conclusion is for the reinstatement costs. And that's not disputed, that's not been challenged so far. And that is a performance interest claim, is it not?
It's not the subject of the present appeal. No. It was the subject of some adverse comment in the Inner House because the Inner House questioned the basis upon which it could ever be a loss in the hands of the tenant to carry out the works of repair that the landlord ex hypothese is obliged to undertake. But the fourth and fifth conclusions are those that relate to loss of profit.
Yeah, but if we're going to sort the law out, we may have to look at the third conclusion as well as the fourth and fifth.
Yeah, I mean, if a majority of in a house was sceptical even about the claim for the repair costs, then it might be helpful for us to clarify that point.
Indeed. The third chapter of the submissions I intend to advance relate more specifically to the appellant's case on transferred loss, how that can be accommodated within the existing common law, in particular what was described by the Lord President as the general rule as to the recoverability of damages, and whether that can be accommodated on a principled and on practical grounds as providing an appropriate exception to that general rule. The fourth chapter will involve looking at whether the Scots law of transferred loss is different to the law of England, and if so, whether that can be justified on principled grounds. And then the fifth chapter will involve a consideration of the remaining objections to the appellant's case that were identified both by the Inner House and by the Respondent. So, turning then to the first chapter, the commercial judge summarised his understanding of the central issue between the parties at paragraphs 20 and 35 of his opinion. Paragraph 20 appears at page 131 of the main bundle. As the court will see, the commercial judge indicated that the issue between the parties largely comes down to whether Scots law is the same as English law, or whether the obiter views expressed by Lord Drummond-Young in Maclaren, Murdoch and Hamilton are to be preferred and accurately represent modern Scots law. And then at paragraph 35 on page 138, his lordship repeated that in similar terms. The approach taken by the majority of the First Division, however, appears to be somewhat different, and in particular, in the opinion of the Lord President at paragraph 32 on page 84 of the main bundle. The Lord President said this: "At the heart of this issue is a simple question: what damages, if any, can the pursuers recover from the defenders as a result of the defenders' breach of the rebuilding obligation under the lease? The answer to that is equally straightforward. It is such damages as will, in monetary terms, place them, as the innocent party, as near as possible in the same position as if the obligation had not been breached." The general rule. Now, having posed that question and answered it at paragraph 32, at paragraph 37 on page 86, the Lord President held that on that ground the pursuer's claim must fail. So at paragraph 37 on page 86, the Lord President said, "The pursuer's claim for damages based upon losses sustained by their subsidiary must fail because, in accordance with the general rule of contract law, they have not sustained these losses." As Lord Pentland explains, the pursuer's approach places no meaningful limits on the extent of these exceptions. If there are exceptions to this rule in cases based on contract, either on narrow or broad grounds, the pursuer's claim does not meet the criteria for either exception. And then in a passage, the rest of the Lord President's opinion on that issue is plainly obiter in light of what his lordship says at paragraph 37. So fundamentally, therefore, the approach of the Lord President was to say that the pursuer's claim failed in limine because of the general rule. Since they were not the party that had suffered the loss of profit, they could not recover the damages in respect of those losses. It's also worth noting what the Lord President had to say about the English authorities so far as transferred loss is concerned. And that begins at paragraph 40 of the Lord President's opinion at page 87. First, his lordship indicated that the inner house must be careful when analysing English authorities because the judges of that court are not qualified to determine English law. At paragraph 41, the Lord President referred to the case of Dunlop against Lambert, of course that being a Scottish appeal to the House of Lords. His lordship referred to the subsequent misunderstanding of that appeal in English cases, leading to the erroneous general principle in shipping law that a consignor could sue the carrier for damages in respect of the loss of a cargo, the so-called Albazero exception. Paragraph 42, with reference to a decision of this court in an English appeal, Swinson, the Lord President indicated that may represent the current thinking of the Supreme Court, and of course we will find out soon enough what the court does think about transferred loss in Scots law. At paragraph 44, the Lord President indicated that whatever the position was under English law, as he put it, there was little reason for Scots law to follow it down a rabbit burrow which had been formed as the result of an admittedly erroneous interpretation of Dunlop against Lambert. So it's plain from the Lord President's opinion that he did not base his opinion upon the English authorities.
No. I mean, his position is really the same as the inner house in Dunlop and Lambert. It hasn't moved on, you know, unless you have title to the property or it's at your risk. You have no standing to claim damages.
Correct. So on the application of the general rule, the claim failed, and so far as the subsequent reception of Lord Clyde's speech in Panatown was concerned, as seen in the Outer House cases of McLaren Murdoch and Axon Well and Marquess of Aberdeen, the Lord President addressed those at paragraph 47 on page 90 and indicated that in none of those cases was there any explanation of where the transfer of loss concept comes from in Scots law beyond Lord Clyde's dictum in Panatown. There may require to be a deeper analysis of that in appropriate case. Suffice to say, for present purposes, the pursuer's case falls into neither the narrow property transfer or broader interest performance common intention to benefit grounds. Mm-hmm. So although the Lord President did not apply the English authorities, he indicated that if one applied the English tests of narrow or broader grounds, the claim would fail, and left hanging, effectively, as it were, the idea that there might be an appropriate case where this needs to be looked at, but by implication, it's not the present case.
The last sentence is quite important because, he's leaving open, effectively, the correctness in Scots law of the approach adopted in the English cases to situations where there is a transfer of property or the case is concerned with the performance interest approach, or the situation where there's a common intention to benefit, which would be very similar to the Scottish common law idea of a jus quasitum tertio. And he's saying, well, we're not in any of those situations here, I think probably because we're dealing with the consequential loss of profit of a subsidiary rather than the sort of damage to property situation that a case like Panatown, for example, was concerned with?
It's neither a transfer of property case, which would be the narrow ground, and nor is it the broader common intention to benefit type of case, not least because at the time this lease was entered into, the current parties were not parties to the lease, and indeed, as the respondent highlights, there is a prohibition or there are restrictions on alienation of the tenant's interest, so we could not be in a common intention to benefit situation either. But if those were the tests, the claim would fail, and that's not disputed, for the avoidance of doubt. The other member of the majority in the First Division was Lord Pentland. At paragraph 93 of his opinion, beginning at page 111 of the bundle, Lord Pentland indicated that he agreed with the Lord President's disposal of the appeal by the application of the general rule. He offered some further observations on the question of transfer loss, but as I've indicated, he concurred with the proposition that the claim failed by the application of the general rule. So against, and as the Dean indicated a short time ago, Lord Malcolm dissented, and in his opinion, echoing the approach that the appellant takes in this appeal, Lord Malcolm, in short, proceeded on the basis that Lord Clyde, in his speech, identified, as it were, a third way, a third ground for the justification for the availability of a transferred loss claim, that Lord Malcolm conceived to be in accordance with the basic principles of Scots common law. My submission will be that that was the interpretation that Lord Drummond-Young placed upon Lord Clyde's speech in McLaren Murdoch, and in turn, that's the interpretation that was placed upon Lord Clyde and Lord Drummond-Young in the subsequent Outer House cases, that there is this third distinct ground upon which a transferred loss claim can be advanced. And I'll come to that passage of Lord Clyde's speech in due course, of course, but it's at page 535E of the report, which is page 822 of the bundle. That's the key part of the speech that I'll be taking the court to shortly. So far as the appellant's case is concerned, the speech of Lord Clyde in Panatown is seminal. It provides the basis for the principle for which the appellant contends. What emerges in my submission from the proceedings before the Inner House and the appeal to this court is that there are effectively three views of what Lord Clyde said in Panatown, and as that was developed by Lord Drummond-Young. So the three views are these. First, that Lord Clyde's rule emerged from nowhere, that it was entirely without support in any authority, and that it is inconsistent with the general rule of the common law. That, in short, in my submission, is the approach the Lord President took. The second interpretation of Lord Clyde's speech is that in the relevant passage, his lordship was simply explaining why he rejected the broader performance interest ground. So rather than providing a freestanding principle as to the availability of a claim for transferred loss, he was simply explaining why he had difficulties with the broader ground as it is characterised. Consistently with that interpretation of Lord Clyde, it is said of Lord Drummond-Young in McLaren Murdoch that his lordship was there not attempting to set out any rule of Scots law, but was rather simply saying that Scots law should follow the majority in Panatown, in other words, the narrow ground, the transfer of property type of ground. So this second interpretation of Lord Clyde's speech and its subsequent application by Lord Drummond-Young is essentially the position adopted by the respondent in this appeal and to some extent by Lord Pentland in his opinion. And then finally, the third view, as I touched upon, is that in Panatown, Lord Clyde identified a third freestanding ground on which transferred loss claims might be allowed. This was described as a realistic and practical ground for the availability of the claim by Lord Clyde, which provides its own comprehensive rationale for the recovery of transferred loss. That is effectively the position of the appellant in this appeal and adopted by Lord Malcolm in the Inner House. And as I touched upon a moment ago, it's effectively the position, in my submission, taken in the subsequent Outer House cases as well.
And did anybody else agree with Lord Clyde in relation to that third ground?
No. But Panatown is a case with 5 speeches, with a 3-2 majority as to the disposal of the appeal. Each of the 5 speeches sophisticated and nuanced analysis of the issues, but there's no adoption of the realistic and practical solution by either of the other members of the majority or the 2 dissenting judges.
Mm-hmm. Even though Lord Gough dissented, was there a majority in favour of his reasoning?
No.
Lord Gough's performance interest analysis did not prevail in Panatown.
Correct.
But it is the basis of your conclusion 3, which isn't contested.
It's never been contested by the respondent to these proceedings. The respondent has never argued that it is incompetent for damages to be sought by the pursuer in respect of a failure to discharge the repairing obligation as such. The debate that took place before the commercial judge and the Inner House on that conclusion was whether it was competent to seek damages because of mutual insurance.
Yes.
And it was the Inner House expressed some...
And we're not concerned with that.
No.
No, but if you stand back, no one is disputing that the principal remedy in Scots law is specific implement, and that the tenant can go to the landlord and say, repair my building. Now, if that's right, and the landlord doesn't do it, I mean, what principled reason is there to prevent the tenant from saying, well, if you won't, give me the money and I'll do it?
So that is absolutely the basis upon which the alternative conclusion for damages was tabled.
Which is it not an application of the performance interest?
It is.
Yes.
It is, unashamedly so. However, I accept it will not avail the pursuer so far as the 4th and 5th conclusions are concerned.
And that's the problem, because you are claiming for someone else's consequential loss.
Correct. So,
we'll no doubt come to it when you come to take us to Panatown, but certainly my reading of Panatown was that Lord Gough was in favour of the broader ground, Lord Millett was in favour of the broader ground. Lord Brown-Wilkinson didn't express a view either way, but proceeded on the basis that the broader ground existed in law. So there were 2 judges who didn't favour the broader ground for the reasons which Lord Clyde gave and Lord Jauncey gave.
yes.
There were 2 that did, and the one that proceeded on the basis that it was correct without deciding that was right.
Yes. So the question of whether the broader ground is a proper basis on which the law should proceed in relation to transferred loss claims is a difficult and complex question, but it does not arise so far as the basis of the claim advanced here is concerned. And I say I'm contending for the 3rd justification for such claims, which the appellant contends can be discerned from Lord Clyde's speech and Lord Drummond-Young's opinion.
But you're contending for it in relation to consequential losses, not just performance interest.
The 3rd ground, yes.
And when we're talking about the narrow ground and the broader ground, am I right in thinking that what you're meaning by the narrow ground is that the explanation for the right of recovery is thought to be that the parties agreed or at any rate envisaged that a third party would benefit from the performance of a contract. So that was always in their contemplation. Is that right?
No,
Right.
the narrow grounds more specifically is to do with the transfer of property.
Oh, I see. Oh, right. I buy a watch for my grandson and it doesn't work, and I can recover despite the fact that it's my grandson who's got the broken watch.
Correct.
Right.
And the law has developed in relation to that over time. In some of the cases, there was a suggestion that had to be the common intention or knowledge that there would be such a transfer, but in other authorities that's seen to be unnecessary. And Lord Clyde says it should be unnecessary, so far as the narrow ground is concerned.
Yes. And so what are you meaning by the broader ground?
The broader ground is the performance interest, where it's contemplated, the common intention of the parties is that someone else will have an interest in the performance of the contract.
Well, Lord Gough doesn't make it dependent on a common intention at all, I don't think.
So, yes, so the performance interest, and the critical point, I suppose, is this, that, and Lord Clyde discusses this in some detail, that the performance interest ground is not really a claim for transferred loss at all, because it proceeds on the hypothesis that as a party to the contract, one has an interest in the counter obligations being performed, which should sound in damages, if not performed.
Yeah. Okay. So for example, if a house I live in is owned by my wife, but I'm the one who earns the salary, and I employ builders to repair the roof, and they don't do it properly, although there's a sense in which the loss is actually my wife's loss because it's her house that has a leaky roof, my interest in the performance of the contract that I paid to have a roof repaired enables me to recover damages. Is that?
That's correct.
Yeah.
That's correct.
Right. And if you like, I mean, ours is essentially the same situation, but it's where my wife is, as it were, carrying on a business from the house, and she's suffering a loss of profits as a result of the leaky roof.
Correct.
Right.
So, as I've indicated, the cornerstone, as it were, of the appellant's case is that Lord Clyde is to be seen as having identified another rationale for the availability of transferred loss, and that the Scottish authorities, such as they are, very limited authority on this topic, all outer house, and beyond that one simply has the speech of Lord Clyde in an English appeal. But the authorities, such as they are, should be understood as speaking with one voice, being the availability of this third rationale. And in the corollary of that in my submission is there is no hint in the Scottish authorities of the broader or narrow grounds being accepted and applied by Scottish courts. Rather, the approach that has been taken in the Scottish authorities is to apply Lord Clyde and then Lord Drummond-Young's approach.
There's no Scottish case where Albuzera has been applied, is that right?
No. Certainly, so far as I'm aware, my lord, the first treatment of transferred loss, if one can call it that, in the modern era, is McLaren Murdoch. Mm-hmm. So, in my submission, that realisation, as it were, is of some assistance in helping to dispose of a complaint that appears in the respondent's case, which is to say this area of law, this principle, has a common origin between Scots and English law in the form of Dunlop against Lambert, and so the respondent says it cannot be right that Scots law could now be different to the law of England if the common origin is the same. And my submission is what we will see from an examination of the authorities is that at some point after Panatown, Scots and English law have headed off in different directions. The Scottish cases have not discussed the English cases after Panatown, and the English cases haven't discussed the Scottish cases at all beyond Dunlop against Lambert. So common origin or not, the two systems have parted company. And in my submission, that's maybe not a surprising state of affairs, that having shared a common origin but then gone their separate ways, having regard to the many differences between the underlying common law, it's not a surprise that they should reach different conclusions to what, after all, in my submission, is a nuanced and complex issue that rationally admits of a number of different explanations and justifications.
It might be said against you that they haven't parted company, because what has happened is Lord Drummond Young, in Ubita Dicta and McLaren Murdoch, has adopted Lord Clyde's analysis of English law.
Mm-hmm. Well, there is a detailed exposition of Lord Clyde's speech in Lord Drummond Young's opinion, and I'll of course be taking the court to it, but my submission is that Lord Drummond Young correctly accommodated the principles set out by Lord Clyde within the framework of Scots law. That's certainly what he in terms endeavoured to do. He in terms said, from the perspective of Scots law, this is what attracts or commends itself to him as the right approach.
It strikes me as curious that if there's a difference, that Scots law should be more reluctant to accept claims of this kind than English law, because English law, of course, has a doctrine of consideration. It has a very strict approach to privity, subject to recent statutory changes, whereas Scots law has always been willing to accept in principle third-party rights to enforce contracts, and it hasn't had a doctrine of consideration.
Well, indeed, and in his dissenting opinion, these are the types of point Lord Malcolm makes in explanation of his conclusion that Scots law should recognise this form of transferred loss, that there are all these differences, with the emphasis on privity in particular being one of them. Just before leaving this particular issue about the dissonance that arises between Scots and English law on the appellant's case, at least, there is a, as I read the respondent's case, there appears to be a suggestion almost of some sort of presumptive correctness of the English authorities so far as Scots law is concerned. And I just wanted to observe in the passing that in the recent case before this court of King Crude Carriers and Ridgebury November, dealing with the Mackay against Dick and Stevenson principle, certainly as I read the judgment of the court didn't feel the need to justify a difference from the law of Scotland. It simply addressed itself to what the law of England and Wales is. And mutatis mutandis, my submission is it should be the same here. So it will be my intention to spend some time looking at the speech of Lord Clyde and the opinion of Lord Drummond Young, because one has to, in my submission, clear the decks, as it were, of the issues that are raised as to what Lord Clyde meant, what Lord Drummond Young meant. And once one does that and arrives at the conclusion for which I contend that there is a third way identified, and that's what's been applied in the Scottish authorities, the court, in my submission, is then, it's an open question for the court to assess for itself whether the principle for which the appellant contends is consistent with the general principles of Scots law.
In introducing the reference to Lord Clyde's passage in his opinion in McLaren Murdoch, Lord Drummond Young referred to the passage as being one that sums up the views of the majority of the House of Lords. That doesn't appear to me to be an accurate summary.
I think there is force in that, Lord, I have to accept.
So if he was proceeding on the basis that this was the views of the majority, then that looks like it was erroneous.
So I accept that when Lord Drummond Young says that Scots law should adopt the decision of the majority, one can see why on a literal reading of that would mean the narrow ground. But as soon as one then looks at the detail of what Lord Drummond Young said in McLaren Murdoch, yes, It's optimistic in my submission of his lordship to say that he is setting out the view of the majority. He is in fact focusing on the speech of Lord Clyde and the rationale that Lord Clyde gave beginning at page 535. So, if I can turn then to chapter 2 of my submissions, which is the chapter in which I look at fire and murder and first at Panatown. As I indicated to the court, there are these three competing interpretations, as it were, of Lord Clyde's speech. And it's appropriate to turn up Panatown. It begins at page 805 in the bundle, and the passage that I wanted to begin with is at page 816. So that's page 529 of the original report. And at the top of the page, there's a reference to the Alba Zero exception as described by Lord Diplock. And as the analysis of the Alba Zero continues, at letter F, the passage in Lord Diplock's speech that's highlighted there is that even out with the particular circumstances that arose in the Alba Zero, this is at letter F, there may still be occasional cases in which the rule would provide a remedy where no other would be available to a person sustaining loss, which under a rational legal system ought to be compensated by the person who has caused it. And it's fair to say that that has been seen to be a driving consideration for the justification of transferred loss claims in all of its guises, that this has to be something that the law considers is worthy of compensation. On page 530, page 817, I just wanted to draw attention to an issue that the court will have seen in the cases for the parties. The question is whether this should be regarded as a rule that depends upon the intention of the parties. Lord Clyde, between letters C and D, offers the view that it is better to regard it as a solution imposed by the law rather than one depending on the intention of the parties, who may never have addressed their attention to it.
Why should that be the case? I mean, we're not talking about the general law. In contract law, parties are choosing to enter into voluntary arrangements which may alter their obligations under the general law. Why is their intention irrelevant? So, if they haven't considered a matter, why is that not relevant?
So in my submission, the rationale that is provided by Lord Clyde and indeed by the whole cohort of cases on transferred loss is that on policy grounds, essentially, there are certain cases where the law considers that it's appropriate that compensation be recoverable. The alternative view is that, of course, which found favour with the majority of the Inner House in the present case, because the majority of the Inner House in the present case, in particular in the opinion of Lord Pentland, expressed the view contracting parties are free to make their own bargains, they should look after their own interests, and if they've entered into arrangements that create the black hole, so be it.
Yeah, but when we're considering cases like Panatown, what we're dealing with, are we not, is giving effect to the contract that the party who doesn't own the property is wishing to have implemented. And if it can't, in Scots law, if it can't be implemented, you have a claim in damages. In English law, you go straight to damages. Yes. With a claim for implementing equity. Why is the intention of the parties irrelevant? Because you can clearly explain Panatown on the basis of Lord Griffiths and Lord Goff's approach that It was simply giving effect to the expectation interest of the contracting parties. I mean, why does the law need to impose a rule on the contracting parties, which the contracting parties, on a matter which the contracting parties haven't addressed?
So, that rationale works for some of the cases, but not all of them, because in some of the cases, it plainly was not within the intention of the parties that anyone other than the parties to the contract would have an interest, and yet, on the transfer of property ground, transferred loss was found to be available.
Which cases in particular are you referring to?
So, there's a discussion of this in, well, and the other aspect of that, just to be clear, is in Linden Gardens, for example, there's a prohibition on assignation. So the very paradigm, as it were...
Sorry, I missed... Sorry,
yeah. Linden Gardens, prohibition on assignation in that case, and despite the prohibition on assignation, the very paradigm of a case where somebody else is not contemplated to have an interest in the rights arising under the contract, transferred loss was still allowed. And in seeking to understand why the law has adopted that approach, in my submission, it must come to this, that a balance has to be struck between various principles, various interests that arise in dealing with contractual claims. So the appellant in these proceedings, for example, accepts that there is a general rule that only the parties to the contract can sue under it, subject, of course, in Scots law to the long-standing jus quasitum tertial, but only the parties can sue. And the general rule also says you can only sue in respect of your own losses. Mm-hmm. But equally, there are questions that arise in the authorities about whether it is right to allow the contract breaker with impunity to breach his contract and not be found liable in damages for that breach. The law, in my submission, is having to balance these competing interests that are in tension one with the other. And there is certainly, that appears to be an underlying rationale for the availability of transferred loss as such. Because where otherwise...
I see, I mean, there could be situations where intention is going to be important. In a Dunlop and Lambert situation might be an example, or the Albazero, because the circumstances in which the parties contract are circumstances where they know that the goods are going to be transferred from hand to hand in the course of the carriage. But you can only make sense of the contractual obligations undertaken on the footing that the parties are intending the consignor to retain a right of action, even if he no longer owns the goods. You might have a situation where it didn't turn on intention, if, for example, a contracting party enters into the contract as the agent of an undisclosed principal. Now, the case I put to you earlier of my engaging builders to carry out roof repairs on the house which is owned by my wife, the builders don't need to know that the house is owned by my wife in order, I'd have thought, for me to have a right to damages if they fail to perform the contract. Now that I think that rests on the concept of the performance interest.
Yes. Yes, that rests on performance interest. But you're having to go beyond performance interest to claim a consequential loss. And I'm questioning, given that this is contract, not the general law, on what basis does the general law say that a party to a contract has a right to make a claim for someone else's consequential loss? Yes,
because he's not suing as an agent or as a trustee. It's not on the basis of subrogation. These are all recognised
categories of exception to the general rule, which of course I accept. So, in the final analysis, what it probably comes to is this, that in the particular circumstances of the present case, the losses for which the pursuer sues are exactly the same losses that it would have suffered if it had been trading from the premises. So on ordinary principles and in that situation, these would have been recoverable damages. They would be within the rule in Hadley and Baxendale and all the other general rules in relation to the calculation and measurement of damages. And that being the case, that this is exactly the type of loss that would otherwise have been occasioned, the object and purpose of the contract in the appellant's submission is best met by recognising that these damages be recoverable, and that allowing these damages to be recoverable by the pursuer, if the pursuer is duly accountable to the person who sustained the loss, does not offend against the compensatory principle of damages.
Mm-hmm. And how does that accommodate different commercial abilities, insofar as the licensee may not be quite as, well, maybe more profitable than the actual tenant himself?
So, and that type of concern is raised in the respondent's case, and if there are issues about the scale and foreseeability of any damages that are sought, on the case the appellant advances, that will be addressed by the application of the usual rules in relation to remoteness and foreseeability and so on. But the way it's put by Lord Clyde, and I'll take the court to the passage in a moment, is it should ultimately be a matter of indifference to the contract breaker which among the group of companies in question suffers the loss. And it shouldn't, to take the example, albeit rationalised on different grounds, and I accept that, but to take the example of the matrimonial property, why does it matter to the contract breaker who actually owns the property? The focus, the order of priority, as it were, that the law should accord to these competing interests in my submission is upon the principle of compensation to reflect real loss caused by a real breach of contract.
Now, we must let you take us to the critical passage at long last.
So, yes, with all that build-up, taking it short, the basis upon which it is contended by the respondent that whatever Lord Clyde has to say is really just about the broader ground. That's to be found at page 819 of the bundle, because at letter D on page 819, Lord Clyde says, I turn accordingly to what was referred to in the argument as the broader ground. And over the next few pages, his lordship subjects the broader ground to critical analysis and comments upon it in some detail. But then, on page 822 of the bundle, page 535 of the report, his lordship identifies, and this is again an example of repairs to the roof of the wife's house, that, for example, in Scots law, the jus quaesitum tertio might provide a solution, assuming, of course, there was a common intention. Not available at the time at common law in England. Interestingly, at letter C, on page 535, his lordship says this, that it's not appropriate to develop the law of jus quaesitum tertio in that way. And then the alternative has to be the adoption of what Lord Diplock in Swain and the Law Society described as a juristic subterfuge to mitigate the effect of the lacuna resulting from the non-recognition of a jus quaesitum tertio. And then Lord Clyde continues, the solution achieved by the operation of law may carry with it some element of artificiality and may not be supportable on any clear or single principle. And I again, in the case for which I contend on behalf of the appellant, one has to recognise in my submission that there is an element of the judicial or the juristic subterfuge. There is an element of difficulty in identifying a single discernible principle, What the appellant has sought to do in its case, though, is to provide such a unifying theory or principle to support its case. And the unifying theory or principle that the appellant has contended for in its written case is to focus upon the compensatory principle and to tie that in to the idea that the claimant in such a case should have a material interest in the losses that the third party has sustained.
So, am I right in thinking that Lord Clyde, but whereas Lord Gough sees the party to the contract as suing for the consequences of non-performance in his own right as a contracting party, Lord Clyde seems to see the party suing as an agent for the person who has actually suffered the loss. He talks about doing so on behalf of the third party.
So to the extent that the law has recognised transferred loss claims in any forms, it proceeds on the basis that the claimant is making the claim on behalf of the party who has suffered the loss. Whether one would characterise that as some form of implied agency is not explored in the authorities, and of course there is a recognised exception to the general rule in the case of agency as such. But certainly the critical passage, the bit that is the seminal part of the speech that the claimant, the appellant in the present case founds on, is what follows next. And that's where Lord Clyde says at letter E, a more realistic and practical solution is to permit the contracting party to recover damages for the loss which he and a third party has suffered, being duly accountable to them in respect of their actual loss, than to construct a theoretical loss in law on the part of the contracting party for which he may be under no duty to account to anyone, since it is to be seen as his own loss. The solution is required where the law will not tolerate a loss caused by a breach of contract to go uncompensated through an absence of privity between the party suffering the loss and the party causing it. In such a case, to avoid the legal black hole, the law will deem the innocent party to be claiming on behalf of himself and any others who have suffered loss. It does not matter that he is not the owner of the property affected, nor that he has not himself suffered any economic loss. He sues for all the loss which has been sustained and is accountable to the others to the extent of their particular loss. So that's the passage that the appellant says is a separate rationale. It's not just an explanation for a rejection of the broader ground, and it's certainly not a recapitulation of what's been described as the narrow ground. What drives this as a matter of principle is necessity. There has to be an absence of an availability of some other remedy, and ultimately it's available because the law does not wish to see the loss in question go uncompensated.
Is that the necessity, that the law does not wish to see a third party's loss being uncompensated?
The strict necessity is that there is no other ground of action available, that there's no other way of that loss being...
That means yes.
Yes.
that you have to have this ground of action, because otherwise the third party's loss is uncompensated.
Yes.
But if the parties had contemplated the third party interest, in Scots law they could have used the jus quaesitum tertium, or since 2017 they could use the 2017 Act to confer on the third party a direct right of action.
Indeed so, and of course...
so where's the black hole?
So the short answer to that in my submission, my Lord, is this, that those types of concern that amount to this, that the black hole could have been avoided by the adoption of some different structure, which is almost a universal truth in any case where transferred loss is claimed, that had the parties arranged their affairs differently, there wouldn't have been a black hole and the loss would have been recoverable. But to make these preconditions, as indeed some of the English cases now seem to do, to make them preconditions to the recovery of transferred loss is counterintuitive, because these are the very features that will render a transferred loss claim unavailable. That there is a right in hearing, for example, in the third party to recover the loss directly or to enforce the contract.
Another way of looking at it might be to say that, it is more, it's closer to the Lord Gough approach, is to say that the contracting party paid for performance. Performance has not been tendered. So in principle, the contracting party has a right to damages. But the damages are limited by the principles of remoteness of damage. And so you only recover such losses as flow directly and naturally from the breach. Now, in a case like the present, the disrepair of the building and the flooding and the necessity to put all that right are clearly losses that flow directly and naturally from the breach. Yes. But it's more difficult to describe the loss of profit of the tenant's subsidiary as a loss that flows directly and naturally from the breach.
Well, and there may be considerations at proof that would affect questions of remoteness and foreseeability. So, for example, in the present case, it has lately been contended by the respondent that the licence in this case is unlawful and unauthorised, which is a disputed issue between the parties, and I say hasn't been pled, but the law will be able to address that type of concern by focusing upon the normal principles as to damages and their recoverability, rather than ruling out ab initio the possibility of a transferred loss claim, in my submission. Just before leaving this part of Lord Clyde's speech, to pick up on some of the observations I've made already, at the foot of page 822 of the bundle, it's recognised, first of all, at letter G, that there's no right on this principle, there's no right inhering in the third party to compel the party to the contract to seek recovery. And in my submission, that's an important limiting factor in the principle for which I contend. So far as the floodgates type arguments that are advanced by the respondent are concerned, this is only likely to be a claim that arises in a situation where there is some kind of relationship between the third party and the pursuer, and Lord Clyde addresses that onto page 823 by talking about how the top of the page, the way his lordship puts it, is, the penultimate line on 822, the problem which has arisen in the present case is one which is most likely to arise in the context of the domestic affairs of a family group or the commercial affairs of a group of companies. How the members of such a group choose to arrange their own affairs among themselves should not be a matter of necessary concern to a third party who has undertaken to one of their number to perform services in which they all have some interest. The loss has been suffered, as it's put, some of the authorities, indifferently, whether it's the tenant or the licensee that has suffered the loss. It's the same loss that would have been suffered by the tenant. So it's very directly related to the performance of the contract in this case.
Subject to the point my Lord Stevens made about the nature of the business or the scale of the business that may be taken by the tenant as compared with the other company contracted.
And in this case, of course, there's a user provision in the lease about what the premises can be used for. And if there are arguments...
The user provisions are pretty wide. They just refer to the planning categories. So really,
yes,
the tenant could have operated any sort of business falling within that fairly wide planning category.
Indeed so, but if and to the extent it turned out that the type of losses that were being claimed were objectionable on Hadley and Baxendale grounds, for example, the principle for which I contend allows for that, because it's made clear by Lord Clyde, it's made clear by Lord Drummond-Young that the normal principles as to availability of damages would apply, principles of remoteness, principles of foreseeability, but they shouldn't rule out the availability of a transferred loss claim as such.
But to limit it, you depend in a corporate group situation on there being a material interest, i.e. that the contracting party has a shareholding interest in the subsidiary.
The material interest that the appellant proposes in its case is not of that literal type. It's rather a material interest in the losses suffered by that third party. But that is most...
What's that mean?
Well, it's most likely, as it's put by both Lord Clyde and Lord Drummond-Young, the types of case where it's likely that the contracting party is going to be interested in recovering damages suffered by a third party is where there is some kind of relationship.
Well, what do you say the material interest is in this case?
Well, in the present case, the material interest is in the loss of profit suffered by, as it happens, a wholly owned subsidiary, and the losses in question take the form of exactly the type of loss of profit that the tenant would have suffered had it traded the business from the premises.
Yes, but what used to be called the proper plaintiff rule was that and you might say proper pursuer rule, proper claimant rule, is that a shareholder cannot sue for the losses of the company in which it has a shareholding. Your proposition would go against that principle, would it not?
Well, in my submission, it wouldn't, because the principle for which I contend is arising in a very particular context, the context being, will the law in this circumstance deem this to be a loss that it will not tolerate to go uncompensated?
Well, a different answer to my Lord's point might be that the proper pursuer rule would apply in a situation where the company, the subsidiary itself, had a right of action. But here, I think it's common ground that the subsidiary has no right of action. So the only person who could sue for the loss would be the contracting party.
Yes, that is true.
Correct.
This limitation that there is no ability to compel the proceedings to be brought. So person C suffers a loss but hasn't got the ability to compel A to bring the proceedings. Is that terribly fair?
Well, it's...
because C is still left in a black hole if A doesn't oblige.
So effectively one comes back to the need to balance competing priorities. And in the articulation of the principle that has appeared in the authorities, it is recognised that the course the law should take is not, as a generality, to confer rights directly on the third party, such as the jus quaesitum tertio did in Scots law, where the conditions for the application of the jus quaesitum tertio were met. This ground of action arises in cases where the jus quaesitum tertio is not available, because on grounds of legal necessity, if there is an ability to sue in one's own name, that's the remedy, there's no black hole. This is about a situation where, in certain unusual circumstances, it has been conceived that the loss should be recoverable, subject to the various limitations and principles that are set out. And also recognising in my submission this overriding question of practicality and reality. Yeah. That how likely is it that the floodgates are going to open? How likely is it that parties to a contract are going to start generally suing for third parties' losses, and where will it end, and that type of argument?
The third party might make it worthwhile doing so. I mean, we're in an age of litigation funding and sharing and whatever. But so would a third party who conferred a share of the recovery on the principal contracting party, would that give the principal contracting party a material interest?
So were that to happen, were that to become apparent that that was what was going on, and on any given facts there was no obvious interest on the part of the party to the contract to recover damages, those are exactly the type of situations that either might be reflected in further development of any policy, because these are ultimately policy decisions the law has made as to recoverability. So it might be reflected in the development of that policy, and separately it might be reflected by controls placed upon the recoverability of damages by principles such as remoteness and foreseeability.
Now, we must let you develop your submissions, otherwise you're going to run out of time.
Indeed, I'm conscious of that. We are due to finish at 12:30. It's certainly my intention, I think, to cut to the chase, if I can, within the next 10 or 15 minutes. And Mr. Ford will be very brief. So that's the key passage of the speech of Lord Clyde. I would want to take Lord Drummond-Young in McLaren Murdoch even more quickly, and that begins at page 921 of the bundle, paragraph 33. So this was the case in which a car dealership was counterclaiming against the architect who had been involved in the design and construction of a new car showroom and was seeking damages for professional negligence. By the time the repair works were carried out, the contracting party did not own the property any longer. It had been transferred to another company in the group. So as Lord Drummond-Young says at paragraph 33, this argument raises the question of the black hole that arose in GUS property management. Lord Drummond-Young ultimately expressed the view that there was no black hole in that case because the contracting party could sue for its losses because the property was damaged and defective at the time it received the property. So, of course, everything that Lord Drummond-Young says about transferred loss is obiter. Paragraph 38 of Lord Drummond-Young's opinion on page 924, Lord Drummond-Young refers to the speech of Lord Clyde and the black hole. And between letters F and G, the court will see that his lordship there quotes the passage from Lord Clyde's speech upon which I place reliance. On page 925, between letters B and C, Lord Drummond-Young explains why he is of the opinion that the jus quaesitum tertio in Scots law is not an adequate solution to the problem of the black hole, an analysis with which I endorse in the present appeal. At paragraph 40 on page 925, his lordship explains why, like Lord Clyde, he did not accept the broader ground as forming an appropriate approach for Scots law to take. And then the critical paragraph of his lordship's opinion is at paragraph 42 on page 926, where his lordship expresses the opinion that the existence of the legal black hole is undesirable. If a breach of contract has caused loss, it should be possible to obtain redress for that loss from the party in breach. Then at letter F, the passage we touched upon earlier, I am accordingly of opinion that Scots law should adopt the same general rule as that applied by the majority of the House of Lords in that case. And just pausing there, as I accepted earlier, that's perhaps an ambitious way of putting things given the difference of views in the members of the Appellate Committee. But then Lord Drummond-Young says, as described by Lord Clyde in the passage quoted at paragraph 38. So that's the third rationale upon which I found.
So which passage are you reading from?
Sorry, my lord. Page 926, and it's around letter
F.
Between D and F.
Thank you very much.
Yes, and Scots law should adopt the same general rule as that applied by the majority, but then more particularly as described by Lord Clyde. Page 927, just above letter B. While the contracting party is obliged to account for the damages recovered, he will, in my opinion, be entitled to the expenses he has incurred. And then this, such an approach has a number of advantages. So that's the In my submission, that's the transferred loss claim on the ground that I have contended for has a number of advantages. In the first place, it provides a solution to the problem of the legal black hole that is capable of almost universal application. In the second place, it permits recovery even in the case of contracts that are incapable of assignation, since it is the original party to the contract who is responsible for the raising of any action. This is particularly important in relation to standard form contracts. And in the third place, it maintains the fundamental principle that a remedy of substantial damages can only be available if there exists a loss capable of being measured in financial terms. That means the usual rules on remoteness will apply. And I commend all of that reasoning to the court. So, moving as quickly as I can from those two judgments, my submission is Lord Clyde in Panatown lays out a principled third ground for recovery. Lord Drummond Young in McLaren Murdoch endorses and develops that and is not simply recapitulating the narrow ground. He is endorsing the third way. So in the interest of time, I'll move on to my third chapter, which concerns the appellant's case on transferred loss. And it comes to this. Lord Clyde in Panatown, Lord Drummond Young in McLaren Murdoch, and then in Lady Smith's opinion in Marquess of Aberdeen and Lord Docherty's opinion in Axon Well. Conscious I may be told I'm wrong about this, but my submission is that both of those opinions proceed on the same essential rationale that one saw in Lord Drummond Young's opinion.
Certainly in Axon, I adopted the passage, but I think it's fair to say that wasn't really the issue that was contested in the case. The contested issue was whether the availability of a non-contractual delictual remedy took one outside in the same way that the availability of a duty of care deed did in Panatown. So that was really the focus of the decision.
And that's quite accepted, of course, my Lord, but what I suppose I would add is thinking about the nature of the damages that were being sought in Axon Well. So they were damages sustained by a group company for breach of a non-solicitation clause, so loss of profits suffered by a group company for the non-solicitation of a clause in a contract to which it was not a party. On no view of things could that be characterised as a narrow ground case. It's not a transfer of property case. And I did not...
No, it proceeded on the basis of Lord Clyde's...
Yes. So it's... and the reason I mention that is there is a suggestion by the respondent that the Scots law is to be understood as the narrow ground. The Scottish Law Commission appears to have taken that view in some of the passages in its 2018 report. But in my submission, it's wrong to do that because Axon Well, to take that as an example, cannot be a narrow ground case. But there is no trace in my submission in the Scottish case law, such as it is prior to the Inner House, in this case, of hostility to transferred loss as such. And there is equally no trace of the narrower, broader grounds being applied as the test for recoverability. Rather, it's the universal solution, or the solution that's capable of almost universal application, that Lord Drummond Young identified. I've recognised already in submission that there is an undoubted tension between the allowance of transferred loss claims at all with the general rule, but the law has pursued a policy of recognising that that general rule should suffer some exceptions The dispute in the present case is as to the boundaries of that category of exceptions. Submitted already that we are really in the territory of policy, and as Lord Clyde adverted to, perhaps more tendentiously put, judicial subterfuge, principles that are not capable of being supportable on any single or clear principle. I endorse and commend to this court the opinion of Lord Malcolm in the Inner House, in his dissenting opinion. If I could, at this stage, really just give the court the references to his opinion. First of all, paragraphs 56 and 58. His Lordship makes the point, first, that damages are described as compensatory, not generally by reference to the person entitled to receive them, but by reference to what's being achieved, compensation. That's what the focus, in our submission, that's the focus of the compensatory principle. And the idea of substitutionary and compensatory redress is respected by the requirement that there be an accounting to the person who has suffered the loss. At paragraph 58, Lord Malcolm highlights that given the number of exceptions that do exist on any view to the general rule, it does raise questions, as his Lordship puts it, as to just how forcefully the general rule should be seen to have. I would, however, want to draw particular attention to paragraph 59 of Lord Malcolm's opinion, beginning on page 96 of the main bundle. Because this captures much of the essence of the argument for the appellant. So page 96, at the foot of the page, paragraph 59, there are two parts to the general rule. The first is that a contract between A and B cannot impose liabilities on C. This makes good sense and has caused no difficulties. As a generality, the second element, namely that the contract affords no rights to C, also makes sense. Absent a clear intention to the contrary, only the parties to a contract should have title to enforce its terms. In the scenario mentioned at the outset, if B defaults and A sits on his hands, C cannot sue on the bargain. But if A is keen to hold B to account on behalf of C, who has no direct means of redress, why should this be refused if otherwise it means that B has breached the contract with impunity? Lord Clyde's realistic and practical solution recognises A's entitlement to performance of B's promise to him and avoids a windfall to an undeserving B. There is no breach of the compensatory principle if, as in the Albazero, the appropriate level of damages are directed through A to the party directly harmed by B's default.
That would cover losses flowing directly and naturally from the breach.
Yes.
It may not cover compensatory losses.
Consequential.
Consequential losses.
Well, but the type of... Ultimately, my submission would be that the type of damages that are claimed here would fall to be assessed at proof as to whether they fall within the Hadley and Baxendale type principles. The test here, of course, is the pursuer bound to fail in establishing that it should have an inquiry on its ability to sue for these losses?
Consequential loss, I mean, it is loss which is consequential upon that party having suffered another form of loss. Is that not right? Let's say your property is damaged and you lose profits. So the consequential loss is a consequence of your property being damaged. The only person who has suffered loss here is the subsidiary in relation to the loss of profits.
Correct. That's accepted.
So what has to go to proof here? I mean, it is not the pursuer's consequential loss, it's the subsidiary's loss.
Well, it depends when one is thinking about what is recoverable as consequential loss. It depends upon whether the focus is upon the person who suffered the loss or the type of loss that was suffered. And my submission is that the type of loss that was suffered here, the inability to use the subjects of let for trade that they were intended to be used for, means that these are in principle, consequential losses that are recoverable.
Well, I mean, the fact that I could have traded but didn't, and someone else traded, is hardly a sufficient basis for saying the other person's trading losses are my losses.
Well, the pursuer in the present case is not trying to characterise these losses as its own. Far from it. It's recognising that these are losses sustained by the third party. But it's saying that from the perspective of the policy of the law, should those losses go uncompensated, should it matter to the contract breaker that it was a licensee that suffered these losses as opposed to the tenant, case for the appellant is it shouldn't matter, because there are different priorities to be accorded to the different rules of law that apply. Now, of course, that's at the heart of what the court has to decide as to whether this type of loss is recoverable. At paragraph 67 of Lord Malcolm's opinion, page 101 of the main bundle, Lord Malcolm refers to the well-known English text, Tritle's Law of Contract, paragraph 1438, that's in the bundle of authorities. And the point that is made there is, effectively, if one is looking for a rationale for this, it is that the need to avoid the black hole in itself generates the remedy. And then Lord Malcolm refers to Lord Justice Ricks in Offer, Hoare and Larkstore. I parroted these words earlier. Where a real loss has been caused by a real breach of contract, there should, if possible, be a real remedy, which directs recovery from the defendant.
Paragraph?
67 on page 101. My apologies. And I was going to take the court to that, but I'll simply give the court the reference, because thinking back to the submission about Scots and English law appear to have parted company, at an earlier point in time, it looks as if the gap wasn't so great, because the case of Offer Hoare, which is in the bundle of authorities, it's number 25 from 2006, the opinion of Lord Justice Ricks in that case, beginning at page 949 of the bundle, is of interest, and the passage that I really wanted to draw to the court's attention begins on page 968, because in a sense everything that I have been endeavouring to say is captured and summarised eloquently and forcefully by Lord Justice Ricks in the passage that begins at paragraph 84 at the foot of page 968. So, 4 lines from the end, discussing the English law as it stood in 2006, the courts are nowadays willing to go far to create a working and developing analysis which will accommodate a claim for substantial damages. Those cases also demonstrate, in my judgment, that if substantial damages may be claimed by the assignor in such circumstances, then there can be no objection to a claim brought by an assignee of a valid assignment in whom both cause of action and loss unite in the same party. We're not concerned with assignations. But then at 85, underlying all these cases can be heard the drumbeat of a constant theme, which could possibly be described as ubi jus ibi remedium. Where there's a right, there's a remedy, of course. The maxim that where there is a right, there is a remedy. But it could also be said the courts are anxious to see, if possible, that where a real loss has been caused by a real breach, a real remedy should be available. And then at 86, the courts have to work with the analytical tools which are to hand, but the essence of the matter is that the general principles which have been developed to ensure that claims are confined to victims, the rule that a party may only claim in respect of his own loss, the rule in favour of privity, and that a wrongdoer should not be made to pay compensation which goes beyond his breach. Rules which, as far as they go, are necessary and fundamental to good order and fairness in the litigation of claims, are not, if at all possible, to be allowed to become instruments of maladjustment and injustice.
It makes quite an important point between D and E rather, that the rule in Dunlop and Lambert and other similar cases developed to meet the needs of commerce, and in the 18th century. And it might be said, I mean, the point he's making really is that in modern commerce, you have, for example, groups of companies in which one member of a group holds the property, another member of a group is a trading company, and that's a familiar way of carrying on modern business. And the law should adapt to accommodate that.
Indeed, and similarly in Panatown, for example, the reason there were different companies involved was for VAT-related reasons, but none of the members of the House of Lords in that case conceived that that in and of itself was a bar to the claim. The bar to the claim in Panatown was the availability of a direct right of action by the collateral warranty. And that, in my submission, is the answer to, in particular, Lord Pentland's observation, parties should arrange their affairs to see to it that there aren't black holes, and if they're not careful to look after their own interests, they have to live with the consequences. My submission is that Lord Justice Rick's analysis is the better and the correct one. My Lords, my Lady, looking at the time...
Yes, we haven't heard from Mr Ford yet.
I have to just draw matters together now and rest otherwise on what's in the written case. I think the court, I hope, has the essence of the case for the appellant. I'll hand over to Mr Ford to deal with the obligation to account. And I should say, it had been my intention to take 5 minutes or so to draw everything together. I've actually just done that in the reference to offer whore. So when Mr Ford is finished, that will be the submissions by the appellant.
Yes, I mean, if you need to use up some of your reply time, you can do that. So it's up to you.
I don't think so at the moment. I'll maybe wait to see what the Dean has to say. I'm obliged.
Thank you very much, Mr Thompson. Yes, Mr Ford.
My Lords, my Lady, the purpose of these brief submissions is to address the issues arising in respect of the obligation to account. The short point for the appellant is that it contends that in Scots law, the pursuer is, as a matter of law, obliged to account to the net as the party suffering the loss for any of the net's losses that are recovered in this action. And it has pleadings to that effect at Article 6.6 of Condescendence. And therefore, to the extent that the Lord President and Lord Pentland were critical of the pursuer's pleaded case, and that they said that the appellant had failed to convene the third party as a defender, or to sue for payment to them, or that there was any obligation to account, they were, in my submission, wrong to do so. I'm going to make four very brief points to expand on that. First, we are dealing here, of course, with the concept of transferred loss. And Lord Clyde helpfully explains that nomenclature in Panatown. This is at PDF page 816, where he says, "It is a loss suffered by the third party but transferred to the promisee, who is then accountable to the third party." It's between the letters C and D, PDF page 816. In my submission, that is a realistic and practical way of looking at the concept of transferred loss. The net's losses are transferred to the appellant, as the appellant is the party who can bring the action under the contract. For those reasons, there is no need to call the third party to the action. And indeed, in my submission, if the third party could be, ought to be, or must be a party to the action brought by the appellant in this case, the basis upon which it becomes necessary to rely on the concept of transferred loss falls away. So, for that reason, in my submission, it is wrong to criticise the appellant's pleaded case for failing to convene the third party as a party to this action. When we're dealing with transferred loss, in my submission, that step simply is not necessary. Moving to my second point, the obligation to account, in my submission, operates, as was clearly explained by Lord Clyde in Panatown, in a passage my learned friend Mr Thompson has already directed the court to, which is at PDF page 822, and it's between the letters E and G. And Lord Clyde makes the point that a more realistic and practical solution is to permit the contracting party to recover damages for the loss which he and a third party has suffered, being duly accountable to them in respect of their actual loss, than to construct a theoretical loss in law on the part of the contracting party, for which he may be under no duty to account to anyone, since it is to be seen as his own loss. And he continues later, just concluding that passage, he sues for all the loss which has been sustained and is accountable to the others to the extent of their particular losses. So, in respect of which it is said, there's no basis for the obligation to account. In my submission, there it is. We have a clear statement of legal principle which applies in a claim for transferred loss in Scots law. I'd also just direct the Court's attention to Lord Drummond-Young's comments on this in McLaren Murdoch in paragraph 42. It's at PDF page 927. Lord Drummond-Young says there, while the contracting party is obliged to account for the damages recovered, he will, in my opinion, be entitled to the expenses that he has incurred in conducting the litigation, so far as he has been unable to recover those from the person in breach of contract. And that's just further discussion in my submission of the way in which the obligation to account arises and falls to be applied. And what this means is that if there is success for the appellant, payment will be made by the respondent to the appellant, and upon receipt of those funds, the obligation to account arises. That is the application of the principles explained in the authorities. It's something that will arise immediately. So it is never going to be the case on the part of the appellant that it has any entitlement to deal as it sees fit with what is recovered or to retain that recovery. And I would simply compare that approach with what is said by Lord Pentland in paragraph 99 of the Inner House opinion and at 103, and also by the Lord President at paragraph 36. It would be helpful to look at those. Lord Pentland's at PDF 115. This is paragraph 99, which begins up the page. About two-thirds down the page, my lords, my lady, the pursuer contends that they are, as a matter of law, bound to account to Lynette as the party suffering the loss for any of Lynette's losses that are recovered for its benefit in this action, but there is no explanation or indication of why they assert that such legal liability on their part arises. There is nothing to suggest that there would be a legally enforceable obligation to account to Lynette for any damages recovered. The pursuers have not sued for damages to be paid to Lynette. They have not chosen to convene Lynette as parties to this action.
I mean, Lord Pentland makes quite an interesting point at the bottom of page 115, where he says that the damages could be attached by the pursuer's creditors. And on your approach, I'm wondering, if a pursuer does recover these damages, does he hold them in trust, or are they attachable by their creditors?
My Lord, that's a question that may arise in an appropriate case, but in my submission it is wrong to address this issue on the basis of what might happen in an insolvency event. One could look at any claim,
an issue for another day.
Or one could look at any claim for damages and say, if a court decides that a pursuer is entitled to payment by a defender, once that decree is passed, are those sums somehow protected in the insolvency of the defender? Now, that would come for another day. In my submission, my Lord, this is just a matter for the law of insolvency. It's not a reason to refuse to recognise transfer.
But it helps us to understand the nature of the obligation. I mean, if it's recovering the damages as some sort of quasi-agent, for example, then he would hold them in trust.
Is there an analogy in personal injury litigation where you get somebody who needs care? Somebody's injured, needs care. The care is provided on a voluntary basis by members of the family, but he's entitled to claim for those costs and holds the damages he recovers has to account to the people that actually provided the care. Is there such an analogy in Scottish law? Sorry for asking the question.
Not that I'm aware of that would be particularly applicable in the circumstances of this case. But there may be specific examples that could be given. Yeah. But simply in the context of this case, I'm not advocating for any specific protection of these damages being recovered. My point is simply, if there is an issue in the law of insolvency, that is for the law of insolvency.
My point is that there may be other circumstances in which Party A can recover damages suffered by C and accounts to that other person. And
yes,
personal injury might be one of them.
Would not disagree with that, my lord.
Yes, I think you see, on Lord Goff's approach, I think the party to the contract recovers damages for the loss of his interest in the performance of the contract. But he then is under a restitutionary obligation, an obligation, effectively an unjust enrichment, to pay part of the damages to the party that actually suffered the loss. So that would be a personal obligation, and the money would be attachable by creditors. As you probably know, Bell's commentaries analyse the whole legal system from what happens in the event of bankruptcy, and it's a very good it's a very good guide to the nature of obligations.
Indeed, my lord, but I would just rest on the submission that I don't think it is appropriate in this case to use the what if there's an insolvency to suggest that is a reason not to find that the obligation to account arises. And in my submission, it's simply something that arises by operation of law, as does this recognised transferred loss principle. Now, the approach of Lord Malcolm, which is to say that it is straightforward to reflect the obligation to account in the court order, in my submission, is something that is useful lest there be any doubt as to whether or not the obligation to account exists, but is not necessarily a crucial component. I would simply commend Lord Malcolm's approach to the court. And just in closing this second point, and my last 2 points are very brief, I would note that the approach of it being accepted that in cases of transferred loss, there is a recovery for which an account must be made to the third party has been applied consistently without critical comment by Lord Drummond-Young and McLaren Murdoch, by Lady Smith and Marquess of Aberdeen, by my Lord Docherty in Axon, and by Lord Braid in this case. And just for completeness, it's also an approach that is reflected by Professor McBride in his textbook on the law of contracts in Scotland. The relevant paragraph is paragraph 2226, and that can be found at PDF page 1149. Third, I make a very brief comment on the approach of the respondent in its written case. The respondent in its written case accepts that, at least insofar as the obligation to account arises in narrow ground claims in English law, neither of the steps proposed by the Lord President and Lord Pentland are considered necessary, because their place is taken by the obligation to account. That is the written case for the respondent at paragraph 69, which can be found at PDF page 67. And to be clear, that the appellant's position in this appeal is that in all instances in which Scots law recognises transferred loss, the obligation to account arises. And insofar as the mechanics of that obligation are concerned, there is no suggestion that there's a difference between the law of England and the law of Scotland in that respect. We may recognise different cases in which transferred loss arises, but insofar as the operation of the obligation to account, there's, in my submission, no reason to adopt a different approach. And on that basis, the respondent has, in my submission, come tantalisingly close to accepting that Lord Pentland and the Lord President in the Inner House were incorrect insofar as they proceeded with their concerns about the manner in which the case had been pled and with the concerns that they raised in respect of the obligation to account. My fourth and final point is simply that in this stage of the action, as my learned friend has alluded to on several occasions, we are dealing with questions of relevancy. And if after proof, if it were to be determined that for any reason there would not be an accounting or that the law would not operate so as to allow the appellant to sue on behalf of the third party in a claim for transferred loss, that can be addressed at this stage. But insofar as assessing relevancy, in my submission, what is pled by the appellant is relevant in law and is fit for inquiry. And to the extent that was criticised in the Inner House by the majority, in my submission, they were wrong to do so. So concluding, for the reasons set out in the written case and in light of what I have submitted to the court today, in my submission, the third and fourth issues both fall to be answered in the negative. The conclusions do not need to express that the appellant is suing on behalf of the third party. They don't need to conclude for payment to the third party. We don't need to be convening third parties into actions for transferred loss. And the recovery of damages does give rise to a legally enforceable obligation to account. I've endeavoured to be brief. Hopefully, the court has managed to follow those submissions, but if there's anything else I can address to assist the court, I'd be happy to do so.
Yeah, we're most grateful to you, Mr. Ford, for your succinctness as well as the clarity of your submissions. Thank you very much.
Obliged, my Lord.
Dean of Faculty.
My Lords, my Lady, on behalf of the respondent, the court is invited to refuse this appeal. The majority of the Inner House was, in my submission, correct, and their reasoning should be affirmed. But what the appellant seeks here is not, in my submission, incremental development. It's not a principled extension of existing doctrine. It is rather an invitation to manufacture from whole cloth a completely new doctrine of contractual damages, never before recognised in any jurisdiction, never before advanced by any litigant, and whose consequences, and this is important, whose consequences, economic and legal, cannot be foreseen by this court or by anyone else. The appellant opens its written case with the homely example of Alf, Bert and Claire. Alf's premises let from Bert, Claire operating the restaurant, Bert breaching the repairing obligation. And the appellant says, well, does Bert escape liability for Claire's lost profits? The question is framed as though the answer must be no, as a matter of common sense. But the framing conceals the real question. The real question is not whether Bert escapes liability. It is to whom is Bert liable and for what? Bert is liable to Alf, his contracting party, for breaches of the lease. If Alf has suffered loss, cost of repairs, loss of rent, diminution in value of the leasehold interest, Bert must compensate him. If Claire has an independent claim in delict, under a collateral warranty, under the 2017 Act, she may pursue it. But what the appellant asks is for something completely different. That Alf should be able to recover Claire's losses despite not having suffered them himself, despite Claire having accepted in a separate contract that she has no claim, and despite Bert knowing nothing of Claire's existence. The proper analogy is not Alf, Bert and Claire, it's Archie, Bob and Charlotte, as put in the respondent's case. Now, because in my submission we are looking at a situation in which the appellant urges pretty fundamental shift.
But you would say anyway, even if their example, on the example posited, whether it accurately summarises the facts here or not, you say there's no right of recovery in respect of the losses suffered by Clare.
Precisely so, and I will come on to make that good. But if I can start with that very brief introduction, if I can start, given what I suggest is a very obvious attempt to expand contractual damages, can I start by urging upon the court the need for judicial restraint? This court needs to proceed with caution because of the expansion that is urged. And in the bundle, 3 cases have been put forward to make that good. And if I could just ask the court to turn them up. In the bundle, the first is OBG and Allen, 1520. This is an attempt to... 1520, my Lord. And at paragraph 305 on that page, the court said, for those of us who share that general view, the question is whether this is simply the development of established principles of the common law to meet the demands of the modern world, or whether it is a more radical step which should be left to Parliament. The great strength of the common law is that judges are free to develop it on a case-by-case basis as new factual situations arise. There comes a point when, as Lord Justice Scrutton once said, if there's no authority for this, it's time we made one. But on what basis do the judges decide to make authority where there was none before, or to modify and adapt such authority as there is? There is no easy answer to this. Whatever we do, we must be consistent with the underlying principles and policy of the law. It must not overstep that indefinable line between the development and elaboration of existing principle and the making of brand new law, which is unquestionably the province of Parliament. It must work with rather than against the grain of legal policy. It must go forward when the law is going forward and draw back when the law is drawing back. Now, in my submission, we will see some resonance of that when we come to see what the Scottish Law Commission said about all of this. And there's an echo of this in what Lord Clyde himself said about being wary about innovation where Parliament had so recently innovated by way of statute. The second case on reticence or caution is Woodland. One finds the relevant passage here in at page 1302, Baroness. Oh, no, sorry, Lord Sumption. No, Baroness Hill. 1302, paragraph 28. Her Ladyship said, the common law is a dynamic instrument. It develops and adapts to meet new situations as they arise. Therein lies its strength. But therein also lies a danger, the danger of unbridled and unprincipled growth to match what the court perceives to be the merits of the particular case. So it must proceed with caution, incrementally by analogy with existing categories, and consistently with some underlying principle. And as I come on, I hope to make good in my submission, that cannot be said of what is urged upon the court here. And finally, and perhaps most tellingly, I take the court to the judgment of my Lords Reid and Hodge in the FII group test claimants case. The court will find this passage at page 1410 of the bundle. Paragraph 239. My Lord said this, as we have indicated, courts, including this court, do not often overturn settled rules of law, and in considering whether to do so, they attach particular importance to the security of settled transactions. Decisions in Kleinwort, Benson and Sempra were exceptional in their readiness to overturn centuries of authority, as the House of Lords enthusiastically adopted the theory of unjust enrichment. Those decisions were criticised by this court in Prudential because of their disregard of the need for judicial development of the law to be justifiable by reference to existing legal principle. Normally, as was stated in a recent judgment of this court, in order to preserve legal certainty, judicial developments of the common law must be based on established principles, building on them incrementally rather than making the more dramatic changes which are the prerogative of the legislature. Considering the practice statement in particular, it states specifically that the court will bear in mind the danger of disturbing retrospectively the basis upon which contracts, settlement of property and fiscal arrangements have been entered into. This court, like the House of Lords before it, has followed that practice. And in my submission, that is what we have here. The court would be disturbing retrospectively the basis upon which contracts have been entered into. In our written case, I won't ask the court to turn this up, but in our written case at paragraph 53, bundle page 63, we cite the guidance of Lord Lowry on the restraint of judge-made law. And as we say in the written case, in my submission, all 5 considerations tell against what is urged upon this court by the appellant. And this court will understand that Scottish Parliament has intervened fairly recently, within the last 10 years, by the 2017 Act. This court will understand that the Scottish Law Commission considered, post the 2017 Act, whether there should be statutory innovation on this very point, and found itself unable to make recommendations. If neither the legislature nor the Commission could identify a generally accepted solution, this court should be deeply reluctant to impose one, particularly one whose reach extends beyond even that which the Commission contemplated, and this is important, and one which would create a schism between the law of Scotland and the law of England and Wales, in a context in which cross-border trade is the norm. Now, my learned friends accept that the English law is stated by the decision of this court in Swinson. They accept that on the test set in Swinson, they cannot succeed. So the schism they argue for is clear. It is clear and it is productive of difficulty and uncertainty, as I'll come on to expand upon. The approach urged upon the court also cuts against the 2017 Act itself. Picking up on observations of my Lord Hodge, that Act sets out how it is that one creates rights that inure to the benefit of a third party. Well, what's the point? What was the point of Parliament deliberately choosing that model, rejecting a different approach, if it actually, the law will just say, as long as you can find material interest, it's all fine. I will come back to the most pertinent question in my submission, is that, again, raised by my Lord Hodge. What does that mean? That was the question he asked my learned friend about half an hour ago. Material interest, what does that mean? If this court heard an answer, I'm afraid I missed it. It's impossible of definition, and that is, again, part of the problem. So if I move from that, the question of what I suggest should be judicial reticence, can I suggest what I say is the true state of the law of Scotland in this regard? Because the appellant's case, in truth, rests upon one passage from one speech in Panetown, Lord Clyde, at page 535, as glossed by Lord Drummondjohn in McLaren Murdoch. Can we look at what those cases actually establish? And I'll do it in a different order from my learned friends. Let's start with McLaren, because it's McLaren that has really been said to have taken this all forward. The first and most important point to note is everything upon which the appellants might found is obiter. That is absolutely clear. If we turn to page 922 in the bundle, in the Scottish Civil Law Reports, version at page 340, so 922, His Lordship at letter B explains that at the material time the building was the property of the present defenders whose counterclaim was in contemplation.
I'm sorry, I haven't found the place. This is page 922.
922, letter B, my lord. At a time when the loss was sustained, the building was the property of the present defenders. Your lordship see that?
No. Paragraph 35?
It's just above B.
Yes, it's
Oh, sorry, B for Bravo. I'm sorry.
I misheard you.
Yes, B for Bravo, my fault. Yep. Yes, at a time when the loss was sustained, the building was the property of the present defenders, and then we can skip down to between C and D. His Lordship said, for these reasons, I am of the opinion that the problem of the black hole does not truly arise in the present case. If I am wrong in that conclusion, however, and then he goes on to say what he does. So everything thereafter is obiter. So what we have here is obiter comments on obiter comments are said to have created some sort of new rule of Scots law. Lord Drummond-Young then, the next thing he did, which is of moment, is he expressly considers and rejects the broader ground. And we see that if we turn down to page 925, in between letters D and E at paragraph 40. I am equally of opinion that the solution favoured by the minority of the House in Panatown is not in accordance with the underlying principles of the Scots law of contract. That solution is based on two propositions: that a party who enters into a contract has an interest in having the contract performed, and that interest is sufficient to entitle them to claim substantial damages if there is any failure in performance. In my opinion, the second of these propositions does not follow from the first. Indeed, the distinction between them is emphasised by the traditional approach of Scots law to contractual remedies. He then looks at the difference between specific implement and the like, and at 41 continues. It does not follow, however, that a party to a contract should be entitled to recover substantial damages merely because he's a party to contract. The remedy of damages is fundamentally different from implement. Implement involves the direct enforcement of a contract and can thus be regarded as the primary remedy. Damages, by contrast, is a secondary substitutionary remedy. The purpose of damages is to provide financial redress for the loss caused. That result is achieved by ordering the party in breach to pay a sum sufficient to place the other party in the same position, had it been performed. Thus, notions of loss and financial redress are central to the remedy. That indicates a loss itself must be substantial, capable of being measured. The mere existence of breach does not of itself create a loss of that nature. The loss is rather something flowing from and independent of the breach. It must be substantial and be measured. So His Lordship is very clearly rejecting the broader ground as a matter of Scots law. As we've already seen, this is a narrow ground case, if it's anything, because it was a property transfer case. So it is an oddity of the present case, the one before my lords and my lady. It is an oddity that in arguing for a far wider ground of recovery, even the broader ground, that my learned friend takes as a starting point the case of McLaren Murdoch, in which the broader ground was rejected as a ground of recovery.
But could the pursuer in this case recover under conclusion 3 without the broader ground?
Yes, I was going to say that. So it's important when we talk about performance interest, it's important we understand what we mean. Because in the authorities we're looking at, the performance interest is the interest of the contracting party to have his bargain concluded, such as to entitle him to recover loss suffered by somebody else. When we're talking about the damage to the leasehold interest here, the interest in enforcing the lease, there's no third party involved. So yes, it's a performance interest claim. I don't demur from that, but it's not a performance interest claim that allows a third party involvement to come in, because the only person whose interest in the lease was damaged by the failure to uphold the premises, to repair the premises, was the contracting party.
But what monetary loss did he suffer?
So it's well recognised that if and there's an echo of this in what Lord Drummond-Young has just said in McLaren Murdoch. Well recognised under the law of Scotland that the primary remedy is specific performance and action ad factum praestandum, per contra in the law of England. It's also well recognised that if the court says to contracting party B, you must do this, and B fails to do it, it's competent to have an alternative remedy for damages to allow A to do it. We're still talking about a discussion between A and B. There is no C. And I've always seen no difficulty in the suggestion that there could be damages that if my clients didn't do what they had to do, that effectively a self-help remedy would be open to the tenant to say, well, you're not doing it, we're going to do it, and you'll have to pay for it. But that's still a contest between A and B within the four contract.
It is indeed,
corners.
but it is it is using damages to enforce performance.
Absolutely. Yeah. No difficulty with that whatsoever, but not for a third party's losses. That's what I see as the crucial difference.
But he could also recover compensatory damages for his own loss.
Of course.
No question about that.
Absolutely. And that's the first and second conclusions. Again, no difficulty with that.
So in the present case, I mean, in addition to the physical damage to the premises, if there had been, for example, a sublease under which rent was payable by the operator of the restaurant, then loss of rent would have been a recoverable head of damage.
Absolutely. And that's why when one's saying, this is a later submission, but given what Lord and the Chair says, let's look at that now. Look at where the black hole is, because in the standard situation envisaged by my Lord and the Chair, you've got a head landlord, you've got a mid-landlord, and you've got a tenant, or you've got a tenant and a subtenant. And in that situation, when the tenant says to the landlord, look what you've done to the premises, they're an absolute mess, I am losing my rent here, then there's no black hole. That's a straightforward contractual claim. That is B against A, claiming for his liability, or it's C against B and it's B against A. Dead simple. Why doesn't that happen here? Because if there is a black hole, it's one they dug themselves. It's one they dug themselves by setting up a situation which had no consent. It's one they set up by setting up a situation which is in breach of the licence. The Leonard friend says not pled. Well, SFI paragraph 11, page 7 of the bundle, and it is pled anyway. It's one which they set up by not taking any rent. They can't say I'm suffering a loss of rent here, and they don't say they're suffering a loss of rent here because there is no rent. And again, it's an oddity of this case. Your normal situation where the premises are sublet would be to say, I've got no rent coming in anymore. They don't say that because they can't say that because there is no rent. And yet at the same time they say, yeah, but look at Lynette's losses. That's very much...
What they do say is that your clients well knew that this was a restaurant. It was going to be run as a restaurant. It was run as a restaurant, and it's just really immaterial. Because if they'd been running as a restaurant, they would have suffered exactly the same loss, or something pretty close to it. Yeah,
and I'm very much coming on to that, my Lord, under reference to, that's part of perhaps a wider discussion on the question of remoteness, because my Leonard friend's answer to much of this is, don't worry, if it's too remote, you'll be fine. And I've got quite a lot to say about that, and if I may, I'll address that point when I come to do that.
While you're answering questions and before we adjourn for lunch, can I just ask, did the parties look to see whether this... we've looked... most of the authorities are English because there are more commercial cases, basically, in the courts in England. We've looked at such Scottish cases as there are. But there must... I would have thought that this may be an issue that's been looked at in other jurisdictions. For example, Australia, Canada, the United States. Has there been any consideration given to other jurisdictions?
We've certainly looked to other jurisdictions. I didn't see anything that was much more helpful in addressing what my learned friend is saying, because for the reason I mentioned right at the outset, no one's ever tried to argue this before. Right. So it would have been great if someone had tried this in Australia or New Zealand. I could have said, look, it doesn't work, but no one's ever tried it, and that's part of my argument. I
mean, is there case law equivalent to and possibly considering Panatown, Leinster, Sludge, and so on in, for example, Australia?
There is. I'll try and come with a synthesis of that after lunch. I don't want to do that off the cuff because we haven't put it in front of the court.
Yeah.
But what we have put in front of the court, and I will possibly get to this before lunch, is we haven't seen everything from Scotland yet.
Right.
And we'll come on to that momentarily. But
I think, not wishing to interrupt you for more than a second, I think the Scottish Law Commission discussed the position in European jurisprudence in their report and said that the draft frame of common reference didn't have any coverage of this. But at the same time, I think Lord Gough in Panetown mentioned an article by a German academic on the subject, which wouldn't necessarily tally with what the Law Commission was saying.
yes, I think that's right. German law certainly very much recognised the jus quasitum in the same way as Scots law did pre-2017.
Yes.
If I might, just before we break for lunch, if I've just finished with what is in McLaren, because in my submission it's really important that we understand to see exactly what Lord Drummond-Young was saying. Hopefully the court is still on page 926.
Yes.
And my learned friend looked at this, but perhaps unsurprisingly, I have a slightly different emphasis to him. Just after letter E in the citation of Panetown.
Which paragraph?
This is paragraph 42, my lord, page 926, yes. Letter E to F. Although the approach of the majority of the House in Panetown was based on a series of English authorities apart from Dunlop, the result is, in my opinion, wholly consistent with principles of Scots law. I am accordingly of opinion that Scots law should adopt the same general rule as that applied by the majority of the House of Lords in that case. Now, if we stopped there, my learned friend's argument wouldn't get off the ground, because he accepts that the majority argument, which is the narrow ground, doesn't work for him. But, as described by Lord Clyde in the passage quoted above, apparently that extends it. In my submission, what we see here is, and in what follows, is an overly expansive synthesis of Panetown that is not accurate. But he is attempting, his lordship is attempting to reflect the majority decision. His lordship says, in effect, the rule comes to this: if breach occurs causing loss that can be measured in financial terms, the party not in breach may recover substantial damages, even if that loss has been sustained by another person. If a loss has been sustained by a person other than the contracting party, however, the contracting party must sue on behalf of that other and must account. The right to raise an action in this way is deemed by law to exist in any case where the loss resulting from the breach of contract occurs to a person other than the contracting party. Now, stated in that way, in particular that last sentence, there is no limitation to the exception. That is why, in the courts below, we have argued that if that sentence is right, the exception has swallowed the rule. The exception being you can only sue for your own losses has been swallowed by the rule, because all you need is a breach and the fact that somebody somewhere has suffered loss. That in turn, our argument that otherwise the exception swallows the rule, is in turn why the appellant tries to qualify the generality by what was said by Lord Drummond-Young here, by using concepts such as material interest. And we'll come on after lunch to look at what that means. And just very finally, over the page, 927, at letter B, again two passages my learned friend looks at, again causes difficulties. Just above B, while the contracting party is obliged to account, he will, in my opinion, be entitled to the expenses he's incurred in conducting the litigation, so far as he's been unable to recover those from the person in breach of contract. How? How's that going to work? If I'm the person that sustained a loss and some well-meaning member of my family, who's the contractor, decides to pursue a completely hopeless action, which fails, and my uncle or my brother or whoever turns around to me and says, really sorry, but I'm in $100,000 hole here because of that action I ran in your behalf that I didn't tell you about. Well, I'm not going to be reaching from the checkbook. And his lordship goes on, such an approach has a number of advantages. In the first place, it provides a solution to the problem of the legal black hole that is capable of almost universal application. So we have the rule's gone, the general rule is gone, it has been totally swallowed by the exception, and this is just a brave new world based on what was said by Lord Clyde and Palatine. In my submission, when we come to look at what was said by Lord Clyde after lunch, that can be seen to be wrong.
Yeah. So I mean, just thinking aloud, just say I bought a ticket for my wife's carriage on a ship, and the ship is involved in a collision through the negligence of the captain, and she drowns. I would have a contractual right to sue, I suppose, for her loss under this principle, and her estate would have a right to sue in delict for her loss. And the law would have to find some way of working out which of those rights takes priority so as to avoid double recovery.
It would, and that's why, and again, we've sought to make that good in the case, and I'll seek to make it better in terms of submissions after lunch. That's why Donoghue against Stevenson happened.
Mm-hmm.
And one of the questions
Yeah.
we have is, what was the point of Donoghue against Stevenson? Mm-hmm. What was the point? Mrs. O'Donoghue's friend could just have sued Mr. Minghella, the owner of the cafe, because there's a contract. I'd like an ice cream float, please. Implied term, don't include any snails. That contract is breached. Is there a material interest in the well-being of your guests to lunch? I'd have thought so. So actually, Donoghue against Stevenson and the nearly 100 years development that was spawned, all unnecessary.
Yes. Well, let's hope we don't encounter any snails in lunch. We'll adjourn now and resume at 2 o'clock.
Thanks.
Yes, dear faculty.
Obliged, my Lord. So before lunch, I was endeavouring to explain that in my submission, what we see in McLaren Murdoch is Lord Drummond-Young saying that he is content that Scots law should follow the majority in Panatown, but then going on to offer what, on closer inspection, is an overly expansive description of what that case holds in terms of the majority. And in order to make that good, can I ask the court to turn up Panatown? And in particular, can we start at page 809 in the bundle? Now, bearing in mind what I've already said about Lord Drummond-Young's description, I suggest one finds telling the passage at page 809, letter H. Lord Clyde, very shortly into his speech, I find no reason to question the general principle that a plaintiff may only recover damages for a loss which he has himself suffered, but there are exceptions to that principle. So that's the general rule. That's Lord Clyde's starting point. And as I submitted just before lunch, if Lord Drummond-Young is right, that general rule is gone. Because of universal application, All you've got to do is find a breach and somebody somewhere that suffered a loss. So that rather points away from the synthesis offered by Lord Drummond-Young, and I suggest the same is apparent as we read on. Page 816. At the foot of that page between G and H, His Lordship cites the Albazero and Lord Diplock, and we see there, the Court's very familiar with this passage, but it hasn't actually been read to them yet, as an application of the principle accepted also in relation to policies of insurance upon goods, in a commercial contract concerning goods where it is in the contemplation of the parties that the proprietary interest in the goods may be transferred from one owner to another after the contract has been entered into and before the breach causing loss, an original party to the contract, if such be the intention of both, is to be treated in law as having entered into the contract for the benefit of all persons who have or may acquire an interest in the goods before they are lost or damaged, and is entitled to recover by way of damages for breach of contract the actual loss sustained by those for whose benefit the contract is entered into. That is the clearest possible distillation of the narrow ground. And there is no suggestion by Lord Clyde that he's doing anything other than following the narrow ground. Page 822, still in the speech of Lord Clyde, and just above, in between letters B and C, 2 points that are of moment. First of all, Lord Clyde says, since Parliament has recently made some inroad into the principle of privity, but has stopped short of admitting a solution to a situation such as the present, it would plainly be inappropriate to enlarge the statutory provision by judicial innovation. Well, that comes back to my comment earlier about judicial reticence. We've got the 2017 Act. What's the point of it, if my learned friend is correct? And then it's interesting to look at what he says next. The alternative has to be the adoption of what Lord Diplock said in Swain, or described as a juristic subterfuge to mitigate the effect of the lacuna resulting from the non-recognition of a jus quaesitum tertio. Well, Scots law's never required that judicial subterfuge, because we've always had the jus quaesitum tertio, and now we have the 2017 Act. So an inauspicious start for this wholesale development of the law. And that is, I respectfully suggest, very clear when we look to what was said by the other two members of the majority. Page 850 is Lord Jauncey. Page 850, letter D, Lord Jauncey says the starting point is the Scots case of Dunlop, treated ever since by textbook writers, and then the description from the Albazero. Scottish textbook writers have been less enthusiastic. Lord Clyde referred to Professor Gloag's comment. Bell's principles, Dunlop against other cases, is cited as vouching the proposition that risk is continued in the seller as an express or implied undertaking of the risk. And Lord Diplock rationalised the rule in Dunlop as an application of the principle, and we've seen that already. Now that's the narrow ground. Lord Jauncey is absolutely not doing anything other than applying the narrow ground. And similarly, if we go to 853, in the citation from Lord Brown-Wilkinson, it's at the top of that page. This is from Lanesta, or St Martin's. Lord Brown-Wilkinson, in the indented passage there. This is from, yes, it is St Martin's. Again, that's all entirely consistent with the narrow ground. And at 855, letter C to D, Lord Jauncey says That rule, that's the rule in Dunlop, provides a remedy where no other would be available for breach of contract in circumstances where it is within the contemplation of contracting parties that breach by one is likely to cause loss to an identified or identifiable stranger to the contract rather than to the other contracting party. Again, it's not suggested by my learned friend that he can bring himself within that rule. And the clearest possible description of the narrow ground is found in the speech of Lord Brown-Wilkinson. Page 862, letter E to F. The narrower ground starts by accepting the basic proposition that A, not owning the land at date of breach can show no compensatable loss. However, the majority of the members of the committee extended the reasoning in the Albazero to cover a case so as to hold where A enters into a contract with B relating to property and it's envisaged by the parties that ownership may be transferred to C, so the consequences of breach will be suffered by C. A has a cause of action to recover from B the loss suffered by C. The clearest possible description of the narrow ground. And without needing to turn it up, that was clearly the view of the Scottish Law Commission, that the Scottish courts recognised the narrow ground. The court will find that in the Law Commission report at 18.25, PDF 1246. Given the Scots law origin of all of this, Dunlop against Lambert, I hope I may be entitled to muse whether Lords Clyde and Johnsey would have expressed themselves in quite the same way if they'd been directed to the correct passage from Gloag on contract. We looked at these passages earlier, or at least one of them, 815 in the bundle. Lord Clyde is referred to page 350 in Gloag. The court finds that at 850, letter B. And in the passage we just looked at, Lord Johnsey at page 850, 850, seems it's the same passage because between E and F, Lord Johnsey is referring back to Lord Clyde's own comment. I beg leave to suggest that was the wrong place to look, and the following is the result of the industries of Malerna Jr., Mr. Reid, over the weekend. I hope the court got the additional extract from
Gloag. Yes, they arrived this morning.
So if the court turns that up, it's just 4 pages. First page is the frontispiece. The second page is the table of cases from Gloag second edition, which I respectfully suggest explains why page 350 was looked at, because Dunlop against Lambert is noted as only being discussed on page 350. And page 350 is the last page in that extract. The court can look at that, but I suggest it's not very helpful. What I suggest is much more helpful is if we turn to page 254, which should be the third page of the PDF. And on the third page of the PDF, lack of interest as objection to title. About 12 lines in, this is Gloag 1929 second edition. And if A and B enter into, does the court have that?
Yes.
And if A and B enter into a particular contract with reference to a thing of which A, at the date of the contract, is owner, and the thing is afterwards transferred by A to C, on terms which leave A without interest in it or liability for its state, the plea of want of interest will debar A from enforcing the contract against B, nor can he obtain damages for B's breach of contract, because in the circumstances figured, he has suffered no loss. So, Gloag, writing 90 years after Dunlop against Lambert, did not even consider that the narrow ground claim would be available. And we can see that, and we can see why, as we read on. In Bloomer & Co., Bloomer employed the Defenders, a firm of ship engineers, to fit up engines in a ship. This ship they had already sold to Ellis & Son, and in the contract of sale had protected themselves from any liability for late delivery owing to the delay of the engineers. Defenders failed to complete the engines within the contract time, and an action of damages was raised by Bloomer and Ellis as joint pursuers. It was held that Ellis, who had in fact suffered loss, had no title to sue because they were not parties to the contract. The instance of Bloomer also failed in respect they had no interest. As they were not liable for the delays of the engineers, and as they had no interest in the ship, they'd suffered no loss, and were therefore suing for damages which they had not sustained. Well, it might be said that Bloomer is the direct ancestor of this case. Pretty much indistinguishable. And it certainly provides no support for what is contended for under Scots law by the appellant. And just to complete what Gloag said, reading on again, in Edinburgh United Breweries, a decision, be it noted, of the House of Lords, in Edinburgh United Breweries, A sold a brewery to B. The amount was fixed on representations made by A. B resold to C at an enhanced price without any relation to annual returns, and the brewery was by arrangement conveyed by A to C. It was afterwards discovered the amount of the annual returns had been overestimated owing to fraudulent entries. B and C brought an action concluding for reduction of the original sale by A on the ground of misrepresentation involved in these false entries. It was not shown that the second sale by B to C was open to challenge. The court proceeded on the footing it was not. It was held that neither B nor C had title to sue. B, because having resold the brewery, he had no further interest in the matter, and C, because he had no title to found on misrepresentations not made to him. Now, quite accept that that was a case about reduction of a contract and not a claim in damages, but it would be rather odd to find that one lacks sufficient interest to seek reduction and yet has sufficient interest to claim damages. So that is why I contend, suggest, submit that if Lords Johnsey and Clyde in Panetown had been pointed to page 254 rather than page 350 of Gloag, we might very well have seen something rather different. Now, I'm not arguing for something revolutionary like my learned friend is. I am simply seeking to meet the case against me, which is that there should be an expansion of the law as understood in terms of the narrower ground and so far as it exists the broader. And my suggestion is not only is that not rooted in principle, not only is that not supported by precedent, it cuts directly across what we see written by the leading writer on contract in Scotland. If I move then from what my submission of the law actually is, can I make some observations on what I suggest is the fundamental incoherence of what is being proposed? And I've touched on this already. It's the width, it's the all-encompassing width of it, now restricted only by material interest and remoteness, and I'll take these in turn. Material interest, let's start with that. If I purchase a car and it's defective and it repeatedly needs to be returned for repairs, well, is there not a material interest on my part in my family and vice versa? So, can I sue for damages on behalf of my son, who's now got to walk to school, on behalf of my wife, who's now got to get taxis to work, on behalf of my mother-in-law, who can no longer have the lasagna brought round by her daughter and has to use Deliveroo? That's all the consequence of what's urged upon the court. That's the sort of expansion we're talking about. It's unprincipled and it's substantial. And looking to the corporate sphere, what does material interest mean? Well, it's easy, isn't it, on the appellant's analysis. In this case, wholly owned subsidiary, what's the problem? But where are the limits? So is one share enough to have a material interest? In BP, surely not. In a company that's only got one issued share, surely. But what if there's 2 shares? What if there's 3 shares? What if there's 4 shares? Where does it stop? And my learned friend only looks down the corporate chain. He says, wholly owned subsidiary, there you go. Well, we not look up. If being owned is enough to give material interest, surely ownership is enough. So it's shareholders. Is that what we're saying now? And how much interrogation of this does there need to be in the familial line? What if Alf and Claire are going through a very acrimonious divorce? Does that have to be tested? Do you still have a material interest in a spouse to whom you don't speak and have no intention ever to speaking again? It's all unprincipled, undefined, and undefinable. Now, the point has been made repeatedly in the courts below and again here. How do you define material interest? And the appellant has been unable to do so, not because of any lack of intellectual capacity on the part of my learned friends, but because the concept is inherently vague. And that alone is a reason for rejecting it. And what I'm putting forward in terms of the shareholders, in terms of the lasagna-deprived mother-in-law, this is not a parade of horribles. This is daily Scottish commercial practice. The inability of the appellant to answer these questions demonstrates just how unworkable it is. So next, and this is where I said I would try and address my Lord Stephen's question. Next, the appellant says, don't worry, remoteness. Remoteness is the answer. It will control the scope of recovery. That's illusory in my submission for various reasons. First, the appellant argues that the respondent should have foreseen that lost profits would arise if its breach caused the premises to close. Well, if that's the test, remoteness provides no limitation at all in any case where premises are let for commercial use. The landlord always knows his premises will be used for trade. The landlord can always foresee that breach will cause trading losses. And the only question is whose losses, and that's the one thing that the appellant contends is totally irrelevant. But it's trite that the remoteness test in contract, reasonable contemplation at the time of contracting, is applied by reference to the type of loss, not by its amount. So if I were standing here and saying, oh, it's too remote, then the inevitable answer that would come from a learned friend to the applause of your lordships and my lady is, that is the wrong question. The only question for remoteness is the type of loss foreseeable? The fact that the quantum of loss is wholly unforeseeable is neither here nor there. It's not a defence. So that means the respondent's exposure is wholly unpredictable and wholly uncontrollable. A landlord who lets premises to a modest cafe can find itself liable for the lost profits of a hedge fund operating from those premises through an undisclosed licence, simply because trading losses were foreseeable as a type of loss.
The lease is unlikely to allow for two such diverse uses.
On the particular facts of this case, I quite accept that. But equally, as your lordship has observed, the user clause is pretty wide. It doesn't take the extremity of the argument that I see under reference to the hedge fund to be able to envisage very different quantum of loss. Maybe not very different types of loss, but very different quantum of loss depending on who's actually in the premises at the time. And the appellant's argument that remoteness is assessed by reference to what the respondent could foresee trading losses, somewhat in tension with its argument that intention is irrelevant and that the doctrine operates as a matter of law regardless of what the parties knew or contemplated. If knowledge is irrelevant to whether the doctrine applies, why is it suddenly relevant on the question on quantum? The appellant can't coherently maintain both propositions. So in my submission, one does not constrain what's urged upon the court with any meaningful boundaries, either by resort to material interest or by resort to remoteness. The next observation I would have is that, and I've touched on this, what is being urged upon the court is truly an inversion of the law of contract and delict. This is a doctrine said to be suitable for a contractual relationship, the limits of which both parties are free to set out in advance, where liability usually arises without proof of fault, and yet it's not suitable for a delictual claim, in which there's no ability to set the limits in advance and where proof of fault is always necessary. Now, my Lord Stevens has pointed out there is an exception to that, but that exception is statutory. Services. The legislature had to intervene for services because the well-recognised common law is, coming back to this, if you yourself have not suffered a loss, you can't sue for it in contract or in delict. That is why, in terms of the Administration of Justice Act, sections 8 and 9, the ability on the behalf of relatives who have provided services gratuitously or who have been denied services of the injured relative, it often is said to have a claim. Of course, they don't have a claim. In fact, the sections say in terms you don't have a claim. They don't have a claim. The section says in terms the injured party can bring the claim and under section 8, subsection 2, has a duty to account. Statutory innovation. So, why is this new liability being imposed in contract? The answer given, and the appellant's case is littered with this, is it's necessary in order to do justice between the parties. That looks awfully like fair, just and reasonable, does it not? And is that not really the province of the world of delict and tort as opposed to the world of contract?
Just trying to think of other examples where there is a duty to account, where you make a claim on behalf of some other person and there's a duty to account. And at present, I'm struggling to think of one.
So, the answer to that, my lord, is that there are all the sorts of situations where it would be recognised that the problem presently facing the appellant wouldn't arise. So if you sue him as a trustee,
yes.
duty to account, fine.
Yeah.
Sue as an agent,
Yeah.
duty to account. But other than that, I share the difficulty. There are statutory impositions, and that's it. So the next point, and it kind of flows from what I've just said, is it has always been a good defence to a claim for damages to say, but you didn't suffer that loss. That's always been a good argument. And apparently that's to go now. I mean, we've mentioned the gratuitous care point, the statutory intervention, but let's imagine, and because we're in the world of contract, it's not just a car crash, it has to be, let's imagine I hire a chauffeur to drive me around. And in breach of contract, because he's got a duty to drive with reasonable care, he causes a crash. And my car needs repaired as a result. And let's envisage that I sue for breach of contract and say, I've had to hire a car in the meantime. The chauffeur's insurer very sensibly says, OK, let's see the receipts. And I say, well, actually, I don't have any receipts because it was my son who was driving me around in his car while mine was being repaired. In today's world, that is a complete defence and probably a motion for indemnity costs. In my learned friend's world, it's all good. There's a new claim on behalf of the son for his petrol money and his time. And that only works, of course, where there's a contract. It doesn't work where there's delict, which is wholly counterintuitive. The statutory intervention in the 1982 Act proceeds on the explicit premise that the common law position is you can't recover for a loss you haven't sustained. That is sought to be inverted. And likewise, I've mentioned this already, how do we explain the innovation of the law in Donoghue against Stevenson? What's the point if it's just material interest and remoteness? The law has always treated the inability of third parties to recover under contracts to which they are strangers as a feature, not a bug. The solution, where a solution is needed, is found in delict, in statute, in collateral warranties, in assignation, in the Jus Quaesitum Tertio or the 2017 Act. These are the tools the law has fashioned, carefully and over centuries. The appellant proposes to render that all OTOs in a stroke, and without regard to the consequences, because all that they say is, don't worry, black hole cases don't come around very often. Well, my Lord Docherty's observation, it shows exactly why that's not right. We live in a litigious world. If my learned friend is right, if there is this massive expansion, these claims will be a daily occurrence. What responsible lawyer sitting looking at a claim for breach of contract, if my learned friend is right, wouldn't have to say, in order to fulfil his duty of care, wouldn't have to say to his client, any family members that have suffered as a result of this, or to be speaking to the company director, anyone in the corporate chain, up, down or sideways, that suffered as a result of this breach of contract, and if so, we better claim for that. Now, as Dean of a faculty which relies on expansion of litigation, I'm absolutely happy with that, but what I can't see any more than could the Law Commission, or can the appellant, or with great respect, can this court, is the downside in terms of economic harm. Now, please don't get me wrong, I understand that floodgates arguments rarely land in this court. But that's usually because they're alarmist in nature and easily dismissed. A moment's consideration of the proposal here, which basically gives a starting point in which all associated companies, undefined, and all family members, undefined, have an interest in each other's contractual affairs. That, I would beg leave to suggest, shows I am not being alarmist. I am signalling the actuality and predicting the consequences. It was that sort of consideration that caused the Scottish Law Commission to draw back from the very limited statutory intervention it had proposed. And bear in mind, what it was looking at was abolition of the recoverability of transferred loss outside contractual provision for its recovery. That was not a course of action that it commended itself. And what had commended itself was effectively a statutory invocation of the narrow ground. The court will see that, again, I'm not going to turn it up, but the court will see that the Commission, chaired, of course, by Lord Pentland, recognised that even modest statutory extension would create a somewhat arbitrary division in the law. That's page 1251 of the bundle, paragraph 18.55. And the proposed reform was confined to cases where the contract was for work upon property, subsequently transferred. Paragraph 18.54 on the same page. And that limited extension couldn't be recommended because the Law Commission didn't have the resources to be able to predict what effect it would have. The appellant seeks recovery in a case involving no property transfer, no known intention to benefit a third party, no communication even of the third party's existence to the contract breaker. And yet this court is meant to be able to be satisfied that it's not imposing something of widespread and dramatic effect. This court is entitled to consider the practical consequences of its decisions for the commercial community. Scotland is a jurisdiction that competes for commercial business. Certainty and predictability of Scots contract law is an asset, not a vulnerability. And what the appellant proposes would inject radical uncertainty into every commercial contract in Scotland. I've said commercial, why have I said that? Every contract, commercial or domestic. No party entering into a contract could know what the full scope of its potential liability might be, because that liability doesn't depend on what was agreed, or on what was known, or even on what was foreseeable, but on the internal arrangements of the counterparty with third parties of whose existence it's completely unaware. The insurance implications alone are staggering. How does one insure against liability for the lost profits of an unknown party whose occupation one never consents to? How does a contractor price a job when its liability extends not merely to its employer's loss, but to the losses of every entity, with a material interest shared with the employer? The consequences are either that such risks become uninsurable, driving up the cost of commerce, or they are priced in at worst case levels to the detriment of everyone. As I've said before, this is not a parade of horribles. This is not me being in any way speculative. This is what will happen. None of this can be assessed by the court. It's precisely why it would need far more in the way of what the Law Commission was able to give it in terms of dedicated resources before one could ever be able to come to a solution such as this. And with great respect for all of the undoubted ability to develop the law that inures in this court does not have the tools to consult. This court does not have the tools to look to the business community and see just how bad this might be. Again, that should give it pause for thought.
I've been looking at Lord Gough again, and he discusses the damages that are recoverable on his approach, and the approach of Lord Griffiths, and because the damages are for the failure to obtain the performance for which the party had paid, the damages are to compensate for that non-performance, and it's quite clear that both Lord Griffiths and Lord Gough regard the appropriate damages as being primarily the cost of performance, so the cost of carrying out remedial works.
Yeah.
And that's what Lord Griffiths says in Leinster, and Lord Gough approves that. He also accepts that if there's a liquidated damages clause for delay, then because performance within the specified time is part of what's being contracted for, it should be possible to obtain the liquidated damages for the delay. There's no suggestion I can see in Panatown that consequential losses, like the loss of profit by the actual occupier of the building, would be recoverable on this footing.
No, and in fact, there are indications in the authorities to the contrary, and I'm going to take the court to those shortly.
That was why I was comparing your conclusion 3 with the broader concept, because in Panatown it was simply the damages for the non-performance of the contract. So it was the sum required to have the contract performed.
Yes.
Yeah.
So there's an analogy, although you can quite rightly say, well, there's no question of a third party involved in where there's an extant lease and you're still a tenant. You can demand performance of that contract.
Yes,
I see that.
I, as I said earlier, I've never had any difficulty with the third conclusion, and I continue not to have a difficulty with the third conclusion, other than, I mean, all that the majority in our House were doing in my submission was saying, well, it's kind of difficult to understand why you need that, because your primary remedy is ad factum praestandum. Your primary remedy is specific implement, do the work. And there was never any suggestion that if told to do the work, they wouldn't do the work. So what role was there for that? But as a matter of strict competence, I quite accept that it's always possible to say, to come back to the court, if a decree ad factum praestandum has not been obtempered, then there must be a remedy. It would be remedium. You must be able to come back to the court and say, well, they won't do it, and now they've folded, and I've got effectively a fund in liquidation. I need a claim on that to get the money back. So, if what I've said already is effectively the generics, or the general proposition, in my submission, the appellant's case gets even more difficult to thole when one looks at the actual facts of the case. The contractual architecture. You've got occupation in breach of lease, and the problem that you're trying to found upon something that's in breach yourself is going to be rather difficult. You've got Clause 8 of the licence, PDF 201. The appellant shall at no time become liable to Lynette for any loss arising from the deficiency in the premises. So the appellant has got no liability at all to Lynette. What's the basis for saying it can claim damages representing losses for which it has no legal liability? Lord Pentland was correct in my submission to identify that as fatal to any claim for an accounting, but it's equally fatal to the underlying claim. If you're not liable to Lynette, then the appellant hasn't suffered Lynette's losses in any legally meaningful sense. The absurd nature of the claim becomes even more apparent if one thinks, well, let's imagine that we had this licence and it wasn't without consent, so it wasn't unlawful. And let's imagine it did not absolve the appellant from any liability from the state of the premises. So then you've got the contractual chain claim I mentioned earlier. The Lynette say to the appellant, premises are grotty, we've lost money, give us it back. Appellant says to the landlord, I've got a straight pass on. The answer, if the licence was otherwise exactly the same, the answer to that would be, well, you've got to mitigate your loss. And you can terminate this licence on 7 days' notice. So, if the case was stronger for Miller and a friend, he would be stuck with 7 days' loss. And I venture to say we wouldn't be in the Supreme Court if we're looking at 7 days' loss. But because it's even worse, because his contract is even worse for him, he can say, well, we just ignore it. We just ignore it. And how can he say we just ignore it? In terms of the written statement of the case, res inter alios acta. But that argument is self-consuming. If the internal arrangements between the appellant and Lynette are res inter alios acta in a question with the respondent, then a fortiori, Lynette's losses are res inter alios acta in a question with the respondent. The appellant cannot simultaneously say, my arrangements with Lynette are none of your business, at the same time as saying Lynette's losses are very much your problem. That is wholly inconsistent. It must choose one or the other. And this is the inherent contradiction in the appellant's case. When it suits the appellant, it relies on the separation between pursuer and Lynette. Lynette's a separate legal person, so res inter alios acta. But it seeks to dissolve that separation when it doesn't suit, on the basis or under the guise of material interest. That is precisely the sort of selective veil piercing against which the court and the law turns its face. Lord Justice Coulson in Nederlandse, again, don't need to turn it up, PDF 1071, paragraph 77, parties cannot rely on the separate nature of companies when it suits them and seek to break down the barriers when it creates difficulties. What this court really has is an appeal to justice. It's not fair, they say. The respondent is escaping the consequences of its breach. As at the outset, that framing assumes what it seeks to prove. The question is not whether breach should have consequences. Of course it does. But whether those consequences should extend to losses suffered by an entity the respondent never contracted with, was never told about, and whose exposure to loss it was entirely out with their control. Justice doesn't operate in one direction only. It was the respondent who entered into the lease with the appellant on certain terms. It priced the lease, it insured the lease, it assessed the risk of the lease on the basis of the law as it was understood to be. It's the appellant who seeks to undo all of that and says, well, otherwise the respondent gets a windfall. But the respondent's not getting a windfall. It's getting the benefit of the contractual bargain it made. The loss the appellant complained of is not a loss that was within the scope of the respondent's undertaking. The respondent undertook to maintain premises let to the appellant for use by the appellant as a restaurant. It did not undertake to indemnify every entity that might, unknown to the respondent, come to trade. And in truth, what the appellant is seeking is not to hold the respondent to its bargain. It's seeking to impose a burden the respondent never agreed to bear. That's not justice. And again, there's been some discussion of this with the court already, but it is important not to lose sight of what's actually being claimed here. There's already a claim for the defects in the premises, the repair costs of the premises. That's all understood. No difficulty. The lost profits, the consequential trading losses of a related entity, not party to the lease, that's what we're talking about. And that matters because consequential losses occupy a specific and carefully delineated place within the law of contract. They are recoverable only under the second limb of Hadley and Baxendale. That is, only if the special circumstances were communicated to and within the contemplation of both parties at the time of contracting. Lynette, not known of, well, certainly not at the time, probably didn't even exist at the time of striking the lease. And for that reason, consequential losses cannot be recovered on the broader ground. And I know my learner friend will say, well, this is irrelevant because I'm not arguing for the broader ground, I'm looking for something else, a third way. But it's of interest to see that, and in line with the discussion with my Lord in the Chair, on the broader ground, consequential losses don't work. Just 3 passages to make that good. Panetown itself, 860. Letter G to H, this is in the speech of Lord Johnsey. Furthermore, consequential loss resulting to third party due to delay and resultant loss of profits would appear to be irrecoverable. A similar comment from David Donaldson QC in And So to Bed, PDF 903.
PDF number?
At 903, my lord.
903.
paragraph 54 at the top of that page. It does not appear to me that Lord Griffiths' approach assists performance interest of Party A to a contract as envisaged by Lord Griffiths in Linden Gardens no more than the obverse of positive obligations, benefit inherent in the performance of those obligations itself to the exclusion of any further consequential loss. And a similar comment in the most recent of the cases, Swinson in this court, page 1023. Lord Mance, paragraph 53 at letter E. Potential difficulties about the theory of performance interest are that it cannot prima facie embrace consequential loss suffered by the company actually as opposed to contractually interested in the quality of the property, etc. So, despite the fact that on any view, if the law is correctly stated by Lord Drummond-Young and McLaren Murdoch, well, the one thing we know he absolutely rejected was if the appellant is correct that consequential losses suffered by an unknown third party are recoverable in the way it suggests, then the entire structure of Hadley and Baxendale is undermined. The distinction between the first and second limbs in Hadley become meaningless if the pursuer can bypass the second limb simply by pointing to a third party's losses and saying, well, I've got a material interest. And it doesn't matter whether you knew about it or not. I've got a material interest. So those are the reasons, my lords and my lady, as to why I say the first and second questions fall to be answered in the way proposed by the respondent. That really just leaves the third and fourth, and the third and fourth questions only matter if the court's not with me on the primary argument, and I'm not going to spend over long on it, but it is perhaps helpful, in particular on the third question, just to try and understand the duty to account point. And in particular, in my submission, that exposes a further incoherence in what's proposed. On the narrow ground recognised in the authorities, there is a duty to account. That seems fairly clear. On the broader ground, the innocent party is suing for its own loss. Lord Gough and Lord Millett holding that the promisee's loss is the failure to receive the contracted for performance measured by the cost of cure or the difference in value. It's the promisee's own loss. You wouldn't be holding that on trust for anyone. That's your own loss. And my learned friend says, well, in every case where his third way applies, you'll be holding it, there'll be a duty to account. Well, why? If the third way he suggests plainly encompasses the narrower and the broader ground, it's so wide. And if within his third way we've got a broader ground case, why would you be holding it on trust for anyone? It's your own loss. And then the question arises, well, what happens if the damages are paid in the day after they're attached by creditors? Question posed of my learned friend Mr. Ford. No answer was forthcoming. Again, not because of any lack of intellectual acuity, because the question's unanswerable. Because this has not been thought through in a way that is capable of being expressed as a coherent legal scheme. It's my learned friends who come to this court asking for this change in the law. It falls to them to explain how it works. And what is it? Is it a constructive trust? If so, how does that work, given that the Scots law on constructive trust is not the same as the English law on constructive trusts? Every trust has a duty to account, but not every duty to account is the result of a trust. So what is it? There's no statutory obligation. And if one imagines the money being handed over and then Lynette saying, well, can we have our money, please? The appellant saying, look at clause 8 of the licence. I'm not responsible to you for anything. arising from the state of the premises, why would I give you a penny piece? So they can just hold on to it. If one wants evidence of a windfall in this case, that would be the windfall. Lord Pentland identified this in the Inner House, paragraph 103. How can a liability on the part of the pursuers to account to Lynette for damages be said to arise in view of the express terms of the licence? That's the question he posed. No answer to that is available. If the accounting obligation is unenforceable, as Clause 8 suggests, then the appellant could retain the damages, and that would be wholly unprincipled. And the fourth question is easily disposed of. If there is no obligation to account, there is no title to sue. You can't sue to recover another's losses unless you're under an obligation to pass them over. So, trying to tie this all together, I return to a point in many ways in which is the one I began with. Everything that the appellant proposes happens here is happening out with the contractual relationship. It's probably, as here, something of which the contract breaker has no knowledge, against which he can neither predict nor insure. The ability of this court to develop the law of Scotland is unquestionable and unquestioned, but retrospectively to impose this sort of expansion in the law of contract on every bargain ever struck under the law of Scotland, in a situation where it can no more predict the outcome than could the Commission, surely cannot be contemplated. It's not a case in which the law...
I'm just thinking it's really, the point you last made about the duty to account, it's really a problem with Lord Clyde's reasoning, which was then adopted by Lord Drummond Young, because on the narrow ground, where the pursuer is suing on behalf of other people, there's no difficulty with a duty to account because he's an agent. Quite. And he's holding the funds in that capacity. And there's no problem with Lord Goff's broad ground because there, as he puts it, the employer is seeking to recover damages for his own account in respect of his own loss.
Yes.
In a sense, the loss being the loss of the performance for which he had contracted. So he gets the money for his own benefit. And the mystery really is where Lord Clyde's duty to account comes from.
Well, Lord Clyde's duty to account, my reading of what Lord Clyde was saying is he's simply adopting what was said by everyone else, which is that in a narrow ground case, where it's not your loss, because there is a contemplation the property will be transferred on, that there is a duty to account in that situation.
Right.
Where we run into, so I don't really have a difficulty with what's said by Lord Clyde in that. Where we do run into problems is when we look to what my learned friends say to this court about that. Because they say all of the claims of this nature are subject to a duty to account. And I say, well, why? If it's the performance interest, who are you holding that on duty to account to? A broader ground case, it's your own loss. Why is there any duty to account? And what's the provenance of that duty to account?
Yes, I see. So you say Lord Clyde is really a version of the narrow ground.
Yes.
And the problem we have here is that the narrow ground is not what's being relied on.
Correct. And nor is the broader. Nor is the broader. And it's important we recognise this, that the appellant comes to this court and says there's two recognised bases. There's a narrower ground, that's definitely the law. There's a broader ground, that might be the law. I can't meet either of them. But I have a third way because of an obiter comment and an obiter comment.
Yes, but they are expressly suing on behalf of the third party.
Yeah.
So it's not a broad ground claim.
It's never been a broad ground claim. That is absolutely fair.
That's not how it's pleaded.
Exactly so. And to be fair, it's always been accepted that they can't get home under either the narrower or the broad. It needs to be It needs to be something of the way of Lord Drummond-Young's all-encompassing last sentence. It just applies whenever you can show loss suffered by breach, which can't be right.
Could I just clarify one point, if I may? You say, and I see the force of it, that whether it's the narrow ground or the broader ground, as we've discussed, the appellant cannot succeed. But at the same time, rather like a deus ex machina, you bring in these two Scottish cases of Bloom and Edinburgh United Breweries, which would potentially challenge the existence of either of those grounds.
I do.
Where's the respondent's stance? I mean,
so that's
do you accept the existence in Scots law of the narrow ground?
So that's why I put it the way that I did after introducing this, which is it's a terribly cowardly way to proceed. But I'm here to meet the attempted development of the law. I have not, until I saw what was in Glogue, I have not attempted at any point to dispute that the narrower ground is part of the law of Scotland, which has been the assumption.
Yes.
Well, and it's derived from Dunlop and Lambert, which of course is a Scottish case in the House of Lords.
Indeed.
I've had a look at the House of Lords judgments in the Edinburgh Breweries. In the Edinburgh Breweries.
Yes.
Case.
United Breweries.
And they don't discuss Dunlop and Lambert and all that line of authority.
No.
A lot of it seems to turn on the effect of a conveyance in superseding previous missives. Which is quite a different point.
It is, but they do expressly engage with the question of interest to sue on the basis that neither party had it. In truth, the real problem for my learned friend would, or for anyone arguing that the narrow ground is part of the law of Scotland is the case of Bloomer. That would have been a case which, if we'd been cited on it, and we just looked at page 350 of Glogue as well, because Lord Clyde very rarely gets things wrong. It was only when Mr. Reid found 254 that we thought, well, hang on a minute. Even the narrower ground might be suspect. Of course, this court has no such impediment. Yes, if this court says, well, that's all very interesting from Bloomer from the late 19th century, but the world has moved on, and the acceptance on the basis of Albazero, albeit probably on the basis of a misconception, but the acceptance of Albazero and Panatown of what is meant by Dunlop is such as to say that's part of the law of Scotland as well. So I don't urge upon the court a conclusion that even the narrower ground's gone.
No.
I don't say that. But what I do say is, on the law as it stands, it is difficult to argue that the broader ground exists. There's no support for that. And a fortiori, the even wider expansion of the law as it stands, argued for by my learned friend, simply does not wash. It has no foundation. And ultimately, what I say to this court is, this is not a case where there is any true uncertainty as to the law. The general rule that a party can recover only its own losses is surely not disputed. And the narrow ground exception is not disputed. What is disputed is whether, in addition to the settled principles, there exists an entirely new, radically wider doctrine, which no court has ever recognised, no academic has ever formulated, and which even the Law Commission has been unable to recommend. The true complaint is not that the law is unclear, it's that the law doesn't produce the result the appellant wants. Well, that's not a basis for making new law, particularly new law whose consequences cannot be foreseen and whose scope cannot be defined. It's not a plea for incremental development of the common law. It is the incitement of judicial vandalism. And I suggest that we get a lot of good sense if we go back nearly 200 years. Baron Alderson in Winterbottom, quoted in Donoghue against Stevenson, page PDF 415.
415.
415, my lady, yes. Winterbottom itself is in the bundle, but the passage I'm interested in is quoted by Lord Buckmaster at 415. The only safe rule is to confine the right to recover to those who enter into the contract. If we go one step beyond that, there is no reason why we should not go 50. That observation nearly 200 years ago has lost none of its force. What the appellant proposes is not one step, it is 50 steps, taken in a single bound, without a map and with no way back. That is not something which this court can contemplate. And for those reasons, my lords and my lady, and subject to any questions from the bench, in my submission, this appeal falls to be refused.
Have you read Bloomer? I'm wondering if you've read Bloomer. I'm just looking at it for the first time, and from the head note, it looks as though it may not be directly in point. It looks as, according to the head note, shipbuilders sell an unfinished ship. They subsequently enter into a contract for work to be done on the ship. The work isn't done, and they and the purchasers then sue the person who should have done the work. And all that's decided is that the purchaser of the ship has no claim because he wasn't a party to the contract, and the terms of the contract didn't confer on him a jus quasitum tertia. So it doesn't seem to be, at least so far as the head note goes, it's not deciding anything about the position of the shipbuilder.
Well, it does. If your lordship reads on, the instance, because Bloomer and Co. were also failed, and this is, from my I perhaps should have provided Bloomer, but having looked at it, my understanding is Gloag's distillation of it is correct when Gloag says the instance of Bloomer and Co. also failed in respect that they had no interest, as they were not liable for the delays of the engineers, and that they had and as they had no interest in the ship, they had suffered no loss, and were therefore suing for damages which they had not sustained. And that was because in their contract, they had protected themselves from any liability for late delivery owing to fault on the part of the engineers, which is the exact analogue of here, Clause 8 in the licence, not liable for any state of the premises. So frankly, it's directly against the narrower ground, but as I say, I'm quite content to accept that the world has moved on since then. But it doesn't support Malone and Friends' case.
Okay, well, we'll just have to read the case.
Yeah. My Lord, I'm terribly sorry. There was one thing your Lordship asked me about Australian law or Commonwealth. Again, great thanks to Mr. Reid. Panatown Albazero hasn't really been considered by the High Court of Australia at all. It's quite remarkable. But that's perhaps because the doctrine doesn't seem to have been accepted into Australian law. And we see that from two cases, both fairly recent. Central Coast Council, 2021, New South Wales Court of Appeal 75, where the court said the approach in Linden Gardens has not been accepted in this country, not this state, in this country. And similarly, Yuan, Y-U-A-N, and O'Neill, 2020, South Australian Supreme Court at 49. Again, the Australian, as I say, not the High Court, but the level below that in terms of state, saying that the Albazero exception has been accepted in a very much more narrower way in Australian law, but the whole broader ground aspect and even the narrower ground not applied in the same way under the law of Australia.
Well, that's very helpful. Thank you and thank you, Mr. Reid, for the assistance. Yes, Mr. Thompson.
Lord, just a few points by way of reply, and I would like to begin actually with the recent question posed by my Lord Hodge relative to some of the authorities relied upon by the respondent, because that question and my learned friend's answer to it exemplifies actually what most of my response to my learned friend's submission actually is, which is the force of the submission made on behalf of the respondent is effectively to deny at every turn the logic of allowing transferred loss claims at all, in any form, in any shape, whether on the broad ground or on the narrow ground or on the ground for which I contend. So at every turn when the court reflects on most of my learned friend's submissions, what one will see is that they amount effectively to a rejection of the very idea of transferred loss. And so far as, for example, the passage in Glogue is concerned, so far as the reference to Winterbottom is concerned, if we go one step beyond restricting a claim to the parties to the contract and the loss suffered by them, we must go 50. On any view, in my submission, the law, I'll come to Scots law in a moment, but the law on any view has moved on very significantly since then. We have had the development that started in Dunlop against Lambert, that was expanded in the Alba Zero, that was expanded in Linden Gardens, and when Panatown came round, again, a further extension. So much of the force of what is said against me in my submission has to be seen in that light. That takes me to effectively where the parties part company at a very early stage. My learned friend says that the case for the appellant involves a completely new doctrine that is entirely unprecedented and entirely unsupported by authority, and that it indeed is contradicted by authority. My submission is to the contrary. If one is looking at the Scottish case law, there is no hint in the Scottish case law of the adoption of the narrow or the broader grounds as they are discussed in the English authorities. And rather, one has the speech of Lord Clyde as interpreted and glossed by Lord Drummond-Young, and then as subsequently interpreted in the Outer House. So that in turn takes me to the reliance by my learned friend upon cases such as OBG and Allen, and the suggestion that this court should be extremely reluctant to develop the law, overturn established principles of the common law, and so on. My submission is that one is very far removed from the types of situation that were in contemplation in those cases. One particular feature of that is the submission that my learned friend the Dean made about the fact that Parliament has recently intervened in the form of the 2017 Act, and that there has also been consideration of matters by the Scottish Law Commission. So, in relation to that, the Scottish Law Commission produced a report that was the precursor to the 2017 Act. That was report number 245. In that report, it was expressly stated at paragraph 1.22 that the Commission intended to address the question of transferred loss later. So the report that led to the 2017 Act is not the 2018 report number 252. When one gets to the Scottish Law Commission's report number 252, it is correct that the Commission conceived that what one would take from the Scottish case law is that the narrow ground appears to be what was accepted in the Scottish cases to date. I've already observed that in my submission that cannot be correct, not least because if one takes the example of Lord Docherty's opinion in Axon Well, that was a case where the transferred loss claim related to loss of profits. And it was nothing to do with the transfer of property either. So the position is that Parliament has not been called upon by the Law Commission to legislate in this area. The legislation that Parliament did enact was the product of a separate report. And it's true that the Scottish Law Commission ultimately offered the view that it was unable to make recommendations. But in my submission, if I'm correct in my characterisation of the state of the law at the moment in Scotland, it is not the appellant that is inviting this court to embark on a radical reformulation of the law, but rather to proceed on the lines that have been set in train for some time already. And indeed, if one read, for example, Professor McBride's work on the law of contract in 2007, my submission is one would see that the articulation of principle there is consistent with the general approach for which the appellant in these proceedings contends. Thinking again about whether the case for which the appellant contends is wholly unprecedented and a remarkable extension of the law, so far as Lord Drummond-Young's opinion is concerned, at paragraph 30 of the respondent's case, it is observed that the case for which the appellant contends is of very considerable width, is how it's put. It's then said that Lord Drummond-Young's obiter dictum in McLaren Murdoch is similarly wide. And indeed, I think that would be a fair understanding of the submissions the Dean has just made, that Lord Drummond-Young's articulation of the principle is extremely wide. Then, far from saying that the principle or proposition for which the appellant contends is unsupported by authority, the respondent then actually argues that the appellant in these proceedings is seeking to narrow the principle from what was articulated by Lord Drummond-Young in McLaren Murdoch. That also is found in paragraph 30 of the respondent's written case. So that the point of departure for the parties in my submission is at this very early stage as to what the state of the law in Scotland at the moment actually is. I wanted to turn briefly then to the position in relation to the licence. It was repeatedly submitted by my learned friend, the Dean, that it is to be regarded as an unlawful licence. For the absolute avoidance of doubt, the appellant disputes that the respondent has ever put that in issue. If it had put it in issue, it would have been responded to. And in short, the appellant does not accept that this respondent would ever be entitled to say that it is unaware of and objects to the licence in question. So far as the provisions of the licence are concerned, however, and in particular the fact that there is no liability inter se as between the tenant, present pursuer, and the licensee is concerned, at paragraph 63 of the respondent's case, the argument is made that this would create a significant anomaly if there was an ability on the part of the pursuer to recover damages in a situation where it was not liable to the licensee. There are two things to say about that. First is, if there were such a liability between the present pursuer and the licensee, there would not be a transferred loss claim, of course, because the present pursuer would simply be suing for its loss in the form of the liability that it incurs to the tenant, to the licensee, for a breach of that contract. In my submission, however, the absence of any liability as between tenant and licensee does not operate so as to exclude the availability of a transferred loss claim, and in that respect I place reliance upon what Lord Clyde said in Panatown at page 531H to 532B, which is pages 818 to 819 of the bundle. The 2 points to note from that passage are these. First, the thing that has been found to exclude the availability of a claim for transferred loss are where there is the conferral of a direct right to sue on the part of the third party, which would either in Scots law arise by the existence of a jus quaesitum tertio or some contractual provision to that effect. So that's the thing that has been found to exclude a claim for transferred loss. But at page 531 G to H, Lord Clyde did identify that the arrangements between the party to the contract on the one hand and the third party on the other might serve to exclude the availability of a transferred loss claim. But as his lordship put it, the law would be slow to find such an intention established where it would leave the black hole. So the law will be slow to exclude the transferred loss claim on the basis of arrangements between these parties. And that, of course, in my submission takes one back to the observations I made earlier that the arrangements between these group companies should be a matter of no material concern to a person in the position of the present respondent. And I also made the observation earlier that one could say that in almost every transferred loss claim. The final points are these, my lords. It was submitted by the Dean that there is a irreconcilable tension in the arguments for the appellant so far as the question of intention is concerned. His submission was, how can it be irrelevant to the availability of a claim for transferred loss on the one hand, and yet relevant to the foreseeability and recoverability of damages? That point is answered by Lord Clyde at page 530 C to H, page 817, where his lordship explains that foreseeability is relevant.
I'm sorry, could you give us that reference again?
Sorry, my lord. Page 817, so it's of the bundle, page 530 of the report between C and H.
Thank you.
Where his lordship contrasts, on the one hand, why intention is not relevant to the availability of transferred loss. It's a solution imposed by law. But on the other, that it's relevant to the question of foreseeability of damages. Okay. And in that respect, I just wanted to make this observation. I think it was submitted by my learned friend that a difficulty for the appellant in the present case is that the claim for consequential loss of profit, he said, would be a claim in the second limb of Hadley and Baxendale. Well, in my submission, that's not correct. At least if what would fall within the second limb of Hadley and Baxendale is if there was some special, unusual feature of the types of loss that might be incurred that would have to be within the specific actual contemplation of the parties. Here we're simply talking about, in my submission, losses that, as to their character, arise in the ordinary course of things. So we're in the first limb of Hadley and Baxendale in my submission. The final point is really just this, so far as the duty to account is concerned. For the avoidance of doubt, the appellant is not saying that in all cases, whether characterised as narrow, broad, or the third way for which the appellant contends, there will always be an obligation to account. And the Dean highlighted the difficulty in accepting that as a matter of logic in the case of broader ground claims. And I absolutely accept that, but the answer to it is the broader ground on closer analysis is not a transferred loss claim at all, because the pursuer is simply suing for its own loss. The case for the appellant is that Scots law on the authority so far has not received the narrow and broad ground distinction. We're left with, in the case of actual transferred loss, it's baked in to the concept of transferred loss that as a matter of law there is an obligation to account, and that obligation to account must arise on the receipt of the damages. It can't pre-exist, because unless and until the damages are recovered, there is nothing to account in respect of. That was all I wanted to say by way of reply, unless there's anything the court wishes to raise with me.
Thank you very much indeed, Mr Thompson.
Obliged.
Well, yes.
I'm not seeking to make any further argument. I forgot to say this. In terms of disposal,
yes.
It is simply a question of the court either allowing the appeal or dismissing the appeal, and on any view there is no requirement for any submissions on costs because there will be no cost consequences to either party standing the settlement. I'm sorry, I should have mentioned.
That's very helpful. Thank you very much.
Could I just clarify that, if I may, please? Given the settlement, there are no pleas in law that you wish to be upheld or anything of that nature.
Correct.
You really just want a judgment on the law.
That's the common position of both parties. On that point, at least, we're agreed.
Okay.
Obliged.
Thank you.
I think the only thing to add is it would follow that the case would have to be remitted back to the Inner House. The parties will then dispose of it per their agreement before the Inner House.
Yes, so good. So we remit, and then you will then file a lodge a joint minute in the Court of Session.
Indeed.
Yes. Well, we're most grateful to Council for their assistance. This is, as Council will appreciate, and any law students or lawyers in the room will appreciate, this is a very important case for Scots law, for Scots law of contract, and it's not at all easy. We've been greatly assisted by very skillful advocacy, and we're grateful for that. We'll have to take some time now to consider the judgment that we'll issue. The court will adjourn.